2024, criminal revision petition was mentioned instead of IA criminal.
What do you want to say?
The matter may kindly be adjourned for today. Because there is in the last order, instead of criminal revision petition is yet to be numbered. Only the IA has been numbered and that number has come as a criminal revision petition. Therefore, instead of criminal revision petition 650, it should have been IS 650, 23.
No, it isn't. I mean,
let it come because in that case, otherwise also the records will come. So let the matter be adjourned for today.
you're for the petition?
Which
For the respondent, we have filed a counter affidavit.
Counter affidavit. Person who did. It will be definitely come after vacation only. After vacation.
Lordship.
May I please the lordship? May I please the lordship? For withdraw lordship, a criminal petition lordship. Tomorrow lordship.
We make the mention before court number. I don't know. Let's see. The court of assembly. 17 হবো নি? 17 হবো নি? Criminal revision, criminal petition, 17. Court number 17.
I beg to mention item number 15, 16 up to 20 lordship. 15 is my lord separate matter, and from 16 onwards up to 20 is my lord tag matter lordship.
My protocol is not available.
Yes, lordship. There is some difficulty lordship.
15 to 20.
Yes, lordship. 15 is separate. This
And
also
15 also protocol is
yes,
available.
yes, yes, lordship.
What is this difficulty?
Some difficulty lordship. Appeal.
Is not appearing today.
Yes. Before vacation not possible. After vacation.
No,
lordship.
before vacation, not at all
Oh.
possible.
After vacation time. madam.
15 or 20, no? Due to some personal inconvenience of Mr. S. Protocol. The learned and this counsel for the cases. 15 you write separately. 15, 14, 15, sorry. 16 or 20 will be same and 15 is separate.
Well, interim order is there also.
In all the matters,
Yes.
interim be continued till next date of listing. List accordingly after vacation.
Highly obliged.
May I please, my lord, we have filed a criminal revision petition, my lord, in which a warrant has been issued, my lord. That may be listed on Friday, 13.
Make a mention before court number 17. Court
17,
number 17, yes.
Lord, first, in respect of first, the criminal revision petition, this court may
That's
allow.
right. The senior bench make a mention over court number 17.
May I please, lordship?
It is not available, my. It is not available. That
What?
court is, honorable court is not available.
No, that I cannot see you take to registry. Talk with the registry. 20,
28, madam.
28.
Yes, madam. We have some difficulties today, madam. This I is for bail.
Who is your senior counsel appearing here?
BK madam.
BK Mahan.
There is an I, madam. Pass it off for the day, madam.
I is for?
I is for bail, madam. This is a 302 meter, madam.
Huh.
Then we adjourn for the day, madam.
Adjourn for the day
Yes,
before
yes.
vacation.
Yes, madam.
Not at all possible.
No, madam.
Not at all possible.
Just it will be
After-
adjourned for the day, madam.
After vacation.
Okay. We'll mention and bring again, madam. Today we have some
Whatever
difficulties.
you like to do
Adjourn for the day, madam.
after 1 week for review. After 1 week.
Oh, that's madam.
May I please the lordship, my lord? Lordship, I beg to mention for listing of a bail application, lordship, second bail application, lordship. Lordship, which was filed on 7/12/2024. Kindly the matter may be listed on tomorrow, lordship. Actually, the urgency is that the petitioner is behind the bar for more than 2 years.
Tomorrow is
lordship.
not possible. Make it on 11th. Wednesday.
Deeply organized.
May I please the lordship?
May I please lordship.
With due consent taking from the other side, your lordship, item 14 may be adjourned for the day.
1-4.
On for your lordship, as my senior is out of session also.
Mr. P.N. Goswami or Kalida?
T. Devi, your lordship, and from the respondent.
Or for the respondent. Have you taken consent of the petitioner side?
Yes,
Yes, I'm for the petitioner.
You have for the petitioner.
But there is an interim that may be accepted.
Interim be continued till next date of listing, list of vacation. At the request made by the learned counsel for the respondent. with the consent of the others.
Item number 40 may be listed on 13.
Huh?
Maybe listed on 13. Item 40,
40.
40, Lordship.
Yes,
Maybe listed on 13, Lordship.
13,
13,
before vacation.
before vocation, Lordship.
Once adjourn. After 1 week, I'll read. If it comes automatically, it will come. After 1 week.
After 1 week, maybe fix the date, Lordship.
No date after 1 week. If it comes, and it comes, because we are listing it shorting and most of matters will be there. So if it is possible, we will
All
put
right,
it.
Lordship.
This criminal petition was fixed for today, but unfortunately has not been listed. And petition is arising out of the order passed by the passed in the DB case. The DB case is fixed on 17th of this
You make
current.
a mention before court number 17.
17th is not available.
Okay, then you make a mention before registry, they will sort it out.
For listing, my lord. And this
Yes.
is bail application for
Ah.
listing, my lord. Maybe on 13, my lord.
I
Friday.
cannot say. He is also new, you also cannot say. 12 and 13, there are lots of matters have already been fixed, in fact. 13,
Regular bail application of this.
no, whatever.
For Friday, my lord. Published.
May I please, Your Lordship, I beg to mention item number 41, my lord. My lord, last 3 occasion it was listed but not reached, my lord. Matter may be taken up at 2, my lord. Is,
You cannot stay at this stage.
lord,
Cannot stay at this stage.
my lord,
We'll make a note. If it's possible, then I'll call you. I'm writing here.
Yes,
If it is possible, then I will get it.
Allah.
May I please, Lordship, my lord, I beg to mention item number 23, my lord. My lord, on the last
23.
occasion, your lordships called for the scan copy of the CD.
Hmm.
And as per office note, I have gone through the record. As per office note 612, my lord, that is not received, my lord. The CD is very
As
much.
per office note 612.
612, my lord. I've gone through the record. My lord,
Is calling CD or case record?
scan copy of the case, right?
Case record.
Yes, my lord. So petition 482, my lord, washing of the
Where from it has to come?
Lokhipur, my lord. Silchar, Kasar Lokhipur. Date may be fixed and reissue the recall the city, my lord.
We have gone through the case
My
diary.
lord. Office note dated 6/12. The video.
23 যাব পাৰিব নেকি?
Respondent number 2 have already appeared. They have filed the affidavit in opposition. And my lord, I have already filed the reply. Yes. My lord, CD is necessary. Yes, my lord.
You're for the petition.
My lord, I am for the petitioner.
T sheet.
T-shirt, my lord.
Mr. T sheet, so and so. It is from the office note dated 6/12/23 that scan copy of the case record is not yet received. In spite of issuance of reminder by the registry. Issue fresh reminder. Directing the learner trial court below to send the case record immediately on or before the next date of listing without fail. Registry will do the needful. List accordingly. It will be after vacation only,
My lord.
after vacation.
Date may be fixed here.
No date. I think.
Unless my.
My please, Lordship. I beg to mention item number 39, Lordship, 39. Service report is awaited as per office note dated 6/12, Lordship.
From whom? For respond number 2.
Lordship.
You're for the petitioner.
I'm for the petitioner, Lordship. Lordship, have it after vacation.
Service report is still awaited. Let the service be awaited. Service report on respond number 2 be awaited till next date of listing. List accordingly after vacation. Will be listed.
There is an
after-
interim order. Which will be done.
Interim was there.
Yes, Lordship.
Interim order will continue till next date of listing.
Deeply.
May it please, Your Lordship. First, I beg to mention some item for listing my criminal leave petition.
Sandeep,
motion.
otherwise this criminal senior bench is court number 17
Fresh.
as per the roster, but I don't know if someone is saying that court number 17 is not available. So contact with the registry, they may advise you.
May I please, Your Lordship. Lordship, beg to mention item number 29 and 30. The conducting counsel S dash has some personal difficulty. Your Lordship.
S dash.
S dash she is the petitioner in item number 29 and respondent in item number 30. and I am for the opposite counsel in both the cases.
Now you're praying for adjournment for that's only.
That's all. She has conveyed me to adjourn for the day.
Consent is being taken.
Consent has been taken.
Puruta system,
They are ready to do, but she is not.
system Puruta. As conveyed by NS as does the learned counsel for the petitioner. As conveyed by MS as does the learned counsel for the petitioner, her inconvenience. The learned counsel for the respondent. You're for the respondent number 2 in 29.
29.
Name is D. Hussain.
D. Hussain is also there.
You are R. A. Muzumdar.
R. M.
R. A. Muzumdar. Wait for an adjournment. It will be after vacation only. Just after vacation.
Oblige.
May I please your lordship? Your lordship, with the consent from the other side, I beg to mention item number 22. Conducting counsel is out of station, your lordship.
My lord,
Matter.
in fact, my lord, I am appearing, I have not been that concerned, but this is a case, my lord, passing of 5 complaints, 138 case, my lord, has been challenged here. There is no provision, my lord, for such a, and they have taken at least 7-8 times, my lord, earlier. So I pray, my lord, that this may be fixed in the first week of 7th of January, my lord, is last chance, my lord. They should be given it.
Otherwise, they're taking adjournment.
Every time, my lord, they are taking it, 5 complaints have been stated, my lord, with one possibility. There is no provision, my lord, that 5 complaints can be passed in a single petition, my lord. Only one complaint can be.
They're seeking for squashing for 5 complaints.
Yes. So it may be 7th, my lord, my learned friend rang me up. So last chance, my lord, is 7th, my lord.
Your senior counsel is who is?
Out of Mr. SP Roy.
Mr.
Every time, my lord, he goes out, my lord, that speaks again.
Your good name?
P. Day.
Her name is P. Day, the learned counsel appearing on behalf of Mr. SP Roy. And also heard Mr. G. L. Salvi, the senior advocate. Assisted by whom?
TJ Sahiwal.
TJ Sahiwal for the respond number 1. For the respond number 1. It is submitted by MSD that due to some personal inconvenience, the engaged counsel, Mr. Roy, is not in a position to conduct the case today and accordingly paid for an adjournment. Stop. Next part, Mr. Sahiwala, the senior advocate, submitted in this regard that they're taking adjournment in every consecutive dates, and wherein every consecutive dates and the criminal petition is filed for quashing of 5 complaint petition. So 5 complaint petition. Stop. The matter is urgent, and accordingly he submitted that a date may be fixed for hearing and that for admission hearing, and that may be considered the last sentence. Next, hearing this submission made by the learning counsel for both sides. Petition cases adjourned today. Fixing 7/1 unit 7/1/2025. With a direction to both the parties to proceed with the case on the next date of listing without fail. List according.
Your lordship, there is an interim order which shall be
So
extended.
you are enjoying the interim, that means.
That is why.
Interim order we continue till next date of listing. Next date, we just suppose we are here, going to hear the matter.
Let's-
Item 1.
May I please, your lordship? Okay, initially this case was registered as Kazolgaon PS case, lordship. Thereafter, under the notification of government issued by the Assam government, lordship, that case was transferred to CBI, lordship. The FIR is at page, lordship, 13. May I read the author?
It's related to banning of unregulated deposits.
Lordship.
May kindly call for the city, Lordship.
Lordship, on earlier occasion, learned standing council, seek time for filing objection. He has already filed the objection, Lordship. So there is nothing in the objection, the learned standing council stated only that the case is under crucial stage. Investigation is on a crucial stage, Lordship. So our concern, Lordship, length of detention, Lordship, last 70 days, we are behind the bar, Lordship. Petitioner number is last 67 days and the petitioner number 1 is 70 days behind the bar, Lordship. So initially this case was registered under the sections which are punishment is under up to 7 days and mandatory period is 7 days, Lordship. Subsequently on 14/11, CBI had added the sections, Lordship, that is IPC 409 and 316 surplus 5 of BNS, Lordship. So regarding this two sections, Lordship, squarely covered case, Lordship, coordinate bench of dishonorable court pass an order and allowed the petitioners to grant default well, Lordship. On parity, Lordship, I am also praying before dishonorable court to grant default well to us, Lordship.
Lordship, my respectful committee, that he's speaking for parity, Lordship. In those cases, Lordship, the sections were added subsequently. And they are entitled as because the right, they have acquired the right. But here in this case, Lordship, within the 60 days period, we have added the section. So they cannot claim parity.
Lordship, what happened, Lordship, CBI mechanically, Lordship, adding those sections to enhance the detention period, Lordship. It is very much apparent, Lordship, and so far concerned to the allegations, Lordship, again, that's Lordship.
Yeah, again, if he,
Therefore,
but
CG is required. Lordship.
he already filed Mr. Bhalo has already filed his written objection.
He has filed already objection.
No, obviously, he has already filed. Last date only he took time, I think.
Yes, yes,
So
Lordship.
accordingly filed, but CD most probably it will be required.
Lordship,
I don't
may
know,
may
there
I
may
read
be
the FIR, Lordship?
because whether it is a crucial stage or there is sufficient progress in investigation, that has to be seen. So I don't know, CD could have been called for in the last occasion also. I don't know why it remains.
Lordship, in the order sheet, there is no specific.
No,
mention
no,
about
no.
Lordship.
I actually it was left out anyway.
Lordship.
My
My humble prayer, Lordship, may I read the FIR, Lordship? What is the gravity of the, nothing is there, Lordship, only 70 to 2,000 rupees was misappropriated, appropriated according to the information.
Preparation of 70,000.
72,000, Lordship. As per the FIR, Lordship, the informant's amount is 72,000. May I read the FIR, Lordship?
No, we are not going to spend the time. If CD requires, then I will CD. Otherwise, if Halloween agrees, then we are going to hear the matter. But
because one person they have taken 70,000, Lordship. There are other person also from whom they have received money, Lordship. Therefore, those things will be revealed only in the city. Here in the
then
FIR,
before vacation, any date can be.
Lordship, let it be on Monday, Lordship, next Monday.
Lordship.
Next Monday is on 15th, 16th.
16th.
16th. Okay, that's 16th. We are fixing it on 16th.
Lordship, what happened, Lordship? And
So and so Mr. Halu, they done a special PP has CBI has already filed his written objection. However, inadvertently, the city was not called for. Let the city be called for matter may be fixed on 16th. 16th.
Deeply obliged.
So we are keeping this one. You have
Okay, Lord.
Item 2. Well, this is a charge sheet case, my lord. Earlier occasion, your lordship declined, my lord. But it is second, my lord, regular bail application. Matter is already charge sheeted, my lord. In the meantime, my lord, I am told, my lord, some, my lord, evidences are taken, my lord. So I am praying, my lord.
Is the case under which section? NDPS.
NDPS, my lord. Only, my lord, at this stage, well, I am praying, my lord, my scan copy of the LCR may be called for, my lord, and matter may be fixed on 18 or 19, my lord.
18, you can be able to. From where?
It will be, yes,
Registry will do the needful for scan copy of the LCR because now otherwise I'm saying from where, which district it has to come.
It will come, my lord, through email, my lord.
Yes, obviously.
Yes. Special case number.
18 poet video. We are listing it on 1812.
my lord, special case number 2 of 2023, my lord, in the pending in the special judge Halakadwal. Diploma.
Mr. Kusami is not available today, DP Kusami. He's available, sir. No, I'm just otherwise. That day one matter was there and it's not clear whether he is in jail, he is in treatment, under treatment. It's not clear. I have gone through the, why you are not also clear? Why? There should be some information with you, whether he is in a forwarding report is also not available, whether he is forwarded, not forwarded, jail, medical, where is he?
But report, as far as CD, using medical.
Ah.
They have submitted that, now they.
Now what is the position then?
I have to instruct from them.
Take instruction, this is we are going to, it was matter was tried to dispose of, but later it has come before us that these are not available. From your submission also, it's not clear whether he is bail, jail, mail, medical, it's not clear. I'll pass the order, take the instructions accordingly and call for a report. I'm passing the order. Now I'm just finishing entire case diary again, if there is any availability. One mention is only there, but no report, nothing is there in fact. By such kind of thing. I'll pass the order, go through the order and then call for it. If you want, then I can give you, send back the CD. If you want to peruse. Otherwise, I have peruse and I have instructed to peruse someone also to see whether this kind of report is available in this case diary or not. But so far as I have seen, it's not there, I think. You take instructions accordingly, otherwise he is in bail. Motion
That's why I will take the. I'll
Yes.
give you the instruction today or only today also. No,
Yes, I'll pass the order now.
Item 4.
Tree kind of ইয়াত ৰখি আছে নেকি চাওকচোন আমি ইয়াৰে কাউন্সিল কোনোবা ৰখি আছে নেকি ট্ৰী কাৰণে হা মাতকচোন কোন ট্ৰী কাৰণে ৰখি আছে
Item 3.
just a second. So there is a VC request.
Yes, sir.
It will become after motion column only.
Last item of motion.
Maybe. What is the difficulty? Otherwise, we face some difficulty through VC, in fact. What is his difficulty?
Also, he is out of station, you know, Mr. Krishna.
Oh, that is not the
Due-
thing. Take a date then.
No,
He is out of
it's-
station. That may be one of the
No,
what
it's
is
urgency, Lordship. That's,
urgency, then he should come here.
but due
What
to,
is there? He will remain outside. He will come and
No,
urgent
due-
matter is urgent.
in
This is not there. If genuinely, if there is any problem, that will be different.
Um,
Your matter is urgent.
due to court proceedings, he went to Allahabad, Lordship.
I don't know.
Lordship, last item of motion, your Lordship.
May come, may not come. Still, let us see, please.
Item 4.
May please, yes, Lordship. Lordship, the present matter is arising out of a NIH proceeding, Lordship. The conviction order is at page 41, Lordship. Last paragraph, Lordship.
41. This is the order.
This is the order, conviction order, Lordship. After that, he preferred a criminal appeal, Lordship, before the session judge Nagaon, Lordship.
Oh.
But the observation has been made by the learned session judge that, Lordship, 20% deposit of the compensation amount, Lordship. The basic contention of the petitioner is he is not in a position to deposit the 20% of the compensation amount, Lordship. So at this stage, Lordship,
No, have you filed any prayer before the
that
revision?
error has been made, Lordship. Lordship may see the order, Lordship.
Where is the order?
Page 43, Lordship, and excerpt 2.
43.
43.
This is the order passed by the appellate court.
Appellate court, that is interlocutory order, Lordship, 29/10/2024, Lordship, third paragraph, Lordship.
So you have made a prayer for exemption.
Yes, Lordship, exemption, Lordship.
What is the ground you have taken?
The condition, financial condition of the present petitioner is not good, Lordship. He's having some financial difficulties, Lordship. And the matter is fixed on 25/1/2025, 24/1/2025, Lordship, before the Sessions Court, Lordship, for further hearing, Lordship,
For further hearing
on the criminal appeal, Lordship. The last date was,
if it is fixed for hearing, then it's okay.
that is correct, Lordship. In the
Oh.
meantime, NBW has been issued by the trial court, Lordship, since there is no
No,
stay order.
now the question is, appeal is accordingly admitted for hearing, subject to payment of 20%.
Yes,
that is
that
there.
is correct, Lord.
So if it is already admitted for hearing and case is fixed for hearing, then what is the issue?
The 20% deposit of 20%, Lordship.
No, it was the subject.
That is correct,
Subject to
Lordship.
condition that 20% will be deposited and the matter will be heard.
Lordship.
But you have said that the subsequent order, it is already fixed for hearing.
Lordship, for necessary order, Lordship, as I have the case status, Lordship.
Which order it is fixed for hearing? You have annexed this order?
No, I do not have that
Then
order.
how can
Lordship,
we say?
Because
It
the
is fixed on
24/1/2025, Lordship. The PO is one on the leave, Lordship, on the last occasion. That's why, Lordship.
Without anything, how can we pass any order?
Similar matter has been dealt with by the coordinate bench of this Nadu court, Lordship. Lordship may have a appraisal of that order. Ma'am,
You annex the order then. Sunny, did you hear?
paragraph 6 and 10, Lord.
No, it is a rule, like there is an exception. I'm saying that it was your prayer was rejected. Maybe rightly, wrongly, whatever.
Yes, Lordship.
But you have said that matter is fixed for hearing. That's what I'm saying.
Yes, Lordship, that is correct.
If it is matter is hearing already, then this subject to condition is no way there. That's what I'm saying. So you have not annexed the order also.
So I have to collect the order, Lordship.
Yes.
File an additional affidavit.
When additional affidavit you file, then only we have come to know that yes, there is an order.
Yes, Lordship.
And issuance of NBWA from where you have
The
to
trial court itself, Lordship. The whole
already issued?
already issued, Lordship.
Already issued. Then file an additional affidavit within this week only. Bring this order, in fact.
Yes,
What is the order passed by?
Yes, sir.
Because order is not here.
Yes, Lordship.
And from this order, it is seen that the NBW cannot be issued by the learned trial court below. As appeal is there, no such direction was there. But subsequent order which you have mentioned,
Yes, sir.
by the subsequent order, there may be an direction to the learned trial court below that whatever their order may be. So if it is there, then it's okay. If it is not there, then it's how can we say? So additional affidavit to an additional affidavit you file. We're listing it in this week only.
Yes, Lordship.
We're listing the matter this week only. Thursday
Friday,
can be
Friday.
listed. Friday. Okay, then Friday. Friday ki tarikh? Huh? 20. Huh? 20 no. 13. 13 fixed code. Enabling the learned counsel for the petitioner. Petitioner side to file the additional affidavit. If to file the additional, we pass the order. They are on it. Okay.
Madam Point.
May it pleases your lordship. Your lordship, this revision petition has been preferred against the order dated 8/11/2024 of the trial court, by which my application for considering me as a juvenile has been dismissed, and I was not considered as a child in conflict with law. Your, my lord, will find the impugned order at page number 45. Page number 45, the operating part being on the next page, that is 10 and 11. Para 10. On perusal of the case record, it appears that the informant has lodged the FIR against one Saddam Hussein, son of Abdul Haq. In the evidence of the informant PW1 and the victim PW2 have also identified the accused as Saddam Hussein and not Saddam Ali. The IO and other witnesses of this case have also mentioned the name of the accused as Saddam Hussein. Moreover, in the examination of the accused under 313 CRPC, the accused put his signature under the name Saddam Hussein and not Saddam Ali. The father's name of the accused was also appears to be not similar. The name of the father of the accused was mentioned in the charge sheet as well as the statement of the accused recorded under 313 CRPC as Abdul Haq, whereas the name of the father of the accused was mentioned in the document submitted by CW2 as Abdul Mia. In view of the above, it reveals that the document submitted by the learned counsel for one Saddam Ali, the evidence and documents of CW2 in the name of Saddam Ali, son of Abdul Mia, cannot be considered to be the relevant documents to establish that the documents are for the accused Saddam Hussein, and as such, the prayer for declaring the accused Saddam Hussein, son of Abdul Haq, as a juvenile could not be considered on the basis of documents in the name of Saddam Ali, son of Abdul Mia. So this was the basic finding that due to difference in surnames, I cannot be considered to be a juvenile on the basis of the documents as well as the evidence adduced by CW1, CW2. CW1 is the evidence of the headmaster of class who has issued the class 8 transfer certificate, and CW2 is of the LP school, concerned LP school where he studied. Now, my lord, may kindly come to page number 20. Or 20 is the FIR. Before that, kindly come to page number 29. 29. Or it's the typed copy is there at page number 27. Now here the court itself records accused Saddam Hussein alias Saddam Ali. This is already there in the court record. Again at page number 31, while deciding his bail petition, this is an application filed by petitioner Mubarak Hussain under section 439 CRPC, praying for bail of accused Muhammad Saddam Hussein alias Saddam Ali. So court itself is recording that he is having an alias name, and that is Saddam Hussein, and Saddam Ali is there. And again, court is disbelieving this on that ground, not on the ground that the documents are false or that the documents are manufactured, but on the ground that his surname appears to be different. But the court itself has recorded. Herein, I am relying upon a judgment. I recently come across the judgment of the Apex Court, Ashwini Kumar Saxena, wherein it has held that the court need not go into a hyper-technical view approach while deciding the age determination inquiry. I'm relying upon para 36. Age determination inquiry contemplated under the JJ Act and rules has nothing to do with an inquiry under other legislations like entry in service, retirement, promotion, etc. There may be situations where the entry made in matriculation or equivalent certificates, date of birth certificate from the school first attended, and even the birth certificate given by a corporation or a municipal authority or a panchayat may not be correct. But court, JJ board, or a committee functioning under the JJ Act is not expected to conduct such a roving inquiry and to go behind those certificates to examine the correctness of those documents kept under the normal course of business. Only in cases where those documents or certificates are found to be fabricated or manipulated, the court, the JJ board, or the committee need to go for medical report for age determination. Herein no medical report was called for, rather even the headmaster they have examined. They brought the original registers which have been exhibited, and they have shown that these are from the original records, but they have done that. In spite of that, on the basis of difference in surname only, my petition was rejected. Now I am relying upon para 37. We have come across several cases in which the trial courts have examined a large number of witnesses on either side, including the conduct of ossification test and calling for odontology report. Even in cases where matriculation or equivalent certificate, the date of birth of certificate from the school last or first attended, the birth certificate given by a corporation or a municipal authority or a panchayat are made available. We have also come across cases where even the courts in a large number of cases express doubts over certificates produced and carry on detailed proof, which is totally unwarranted. Now, I'm relying upon para 42. Legislature and the rule-making authority in their wisdom have in categorical terms explained how to proceed with age determination inquiry. Further, Rule 12 has also fixed a time limit of 30 days to determine the age of the juvenility from the date of making the application for the said purpose. Further, it is also evident from the rule that if the assessment of age could not be done, the benefit would go to the child or juvenile considering his or her age on lower side within the margin of 1 year. So my submission is that on the date of incidence of the occurrence, he was 17 years, 3 months, 22 days old. So even the 1 year margin is also being covered here very nicely. And para 45, we are of the view that the admission register in the school in which the candidate first attended is a relevant piece of evidence of the date of birth. The reasoning that the parents could have entered a wrong date of birth in the admission register, hence not a correct date of birth, is equal to thinking that parents would do so in anticipation that child would commit a crime in future, and in that situation, they could successfully raise a claim of juvenility. So in the register, it is there, 2003, his birth year. So on the date of the occurrence of the incident, he was 17 years, 3 months, and 22 days. And my petition was not rejected, not on any other ground, but on the ground that the surnames don't match, where the court himself is recording that he is Saddam Hussein alias Saddam Ali. And so many orders.
Yes.
Otherwise, Lordship, as page 46, his father's name is not found to be similar also. So that's the, at this stage, notice should go and understand what we call it.
And I pray for stay of the further proceedings. The
Why?
case is fixed on 18th of December for arguments. Please still next
So
week.
you took the entire case trial period, you remained silent. And only on 13 you took the plea.
I can do that.
Huh?
I can do that because there was change
No,
of
no, no,
counsel.
no. Entire trial, you
Oh.
remain silent. You have
Entire-
not taken that plea of juvenility. And at the last hour, that is on 3:13, you took this.
But I have been informed that there was a change of counsel, and the new counsel, he suggested
No,
that
whatever, it
it could have been
you have not
taken.
taken any such kind of plea earlier.
No,
And that too, it is a POSCO case. How can we stay past the order on stay in the POSCO matter? POSCO cannot be stayed. He could have come a bit early only, before recording of 3:13 or after recording. It's fixed for argument.
it's fixed for argument on 18th.
Take an adjournment on that day somehow, because POSCO cannot be stayed. Take an adjournment on 18th of this
On
month.
18th of December.
And probability of fixing date, the next date is there in the month of January
In
only,
the
I
month
think.
of January. it will be.
So we can fix it immediately after vacation then.
After vacation.
Third will be the opening day. Fourth is
Saturday. Holiday.
Saturday, Sunday,
Yes,
That is fixed.
on 8th or 7th.
8 or 7th.
Yes.
7th
or
is here in this, 7th is again.
So can it be on 8th?
8.
Can be on 8. Okay. Heard Mr.
AI Ahmed.
A.I. Ahmed, the learned counsel for the petition. I also heard Mr. M.S. S.H. Pora, the learned additional PP, so and so. Pakihi Likhitibo, this is an application, section so and so. Issue notice to the respond number 2. No formal notice is required to be served, so and so. Also call for the scanned copy of DLC. Just matter accordingly. So 8th of January.
8th of January.
We are fixing it on 8th of January, calling for the case record. By the time we take an adjournment for 1 day only, we'll see to it pass the order.
And if I can add one thing that,
Yes.
Lordship, as it is a POSCO case, the victim has denied to undergo even medical examination, and that is there on the record. So let the LCR come.
In the meantime, Lordship, notice should go to the respondent number 2
Through
through
res-
registry clerk.
Respondent
yes,
to
yes.
informant.
It is the proper channel it will go.
Yes.
To the judicial police system, through office of the registry and the public prosecutor. Okay, we'll go in that manner only. Now, what is the medical examination?
The medical examination she denied. The medical officer has filed a report that she has not undergone the medical examination.
No, it is not the case, I think.
That order is also there, the record.
No, we are simply on that whether he is a juvenile or not. That must be.
Deeply obliged.
Okay.
Item 6,
Please, your lordship.
Yes.
Lordship, matter pertains to imposing of a bank guarantee in cattle preservation, and your lordship probably will not take the lordship adjourn for a day, your lordship.
We'll make it list after 1 week then,
Lordship.
list after 1. To make the approach before the race.
Lordship. Much.
Lordship, matter may be taken after few times.
Okay. May it please your lordship. Lordship, in this, the interim had been already been given. And the last occasion, the LCR was called for. So, my lord, this entire matter is this, that at page 33, my lord may come.
Lordship, in this
No,
case,
but,
lordship,
it's-
wrongly listed motion, lordship. Actually, in this case, lordship.
Yes, it should have been listed for admission hearing. Because it has been wrongly listed motion, because the interim has already been given, I have already taken steps. The only factual point or the law point that my lord has to decide is that whether 506 can stand on its own when 420 and 406 has been wiped off. 420 and 406.
Yes, what to do? It is in motion column, which is admission.
Now my lord will fix it for admission hearing.
Okay, otherwise you have appeared already. For the response number 2. You Mr. SP Sharma.
Yes.
Heard Mr. SP Sharma, the learned counsel for the petitioner. And also heard
Yeah.
MSSH Bora, the learned additional PP for the state respondent number 1. And you are MS?
Yeah.
G Akhtar, appearing for the response number 2. We have received the scan copy also.
Yes, we have.
Scan copy of the case record had already been received. And the interim order is also continuing. Accordingly, it is submitted by learned counsel for both sides. The matter ought to have been listed in admission column. Raised is accordingly directed to list the matter in admission column. Is there any urgency?
My lord may list it after the vacation.
After vacation? No, date cannot be given. After vacation only?
Yes.
We immediately after vacation will write, okay? List immediately after vacation.
My lord, if
Interim
please,
is there.
my lord, can it be after Bihu vacation? If after because
They may be in.
because on the first week, my lord, there are some I would not be there. Then again, it'll be difficulty. So after Bihu vacation, it will be set 1 week court.
Immediately
After
after
Bihu vacation, I think it's not a problem.
Okay, after vacation, your interim will be continued till
Yes,
the
madam.
posting. Otherwise, they may have some urgency also.
My lord. Most of it.
After vacation, this interim be continued till next year.
Item 9 for time being after some time, my senior legal lordship.
9 is time.
Please, your lordship. Lordship, this petition has been preferred challenging the impugned judgment and order at annexure 37 page, sorry.
Annexure 37.
Annexure 8 page number 37 unit. Lordship, initially a proceeding under section 130 CRPC was drawn up at the behest of the instant petitioner, your lordship. Against that, the second party, the respondent number 234, challenging the order. Lordship may find it at page number 35, your lordship. Passed by the
Here the
learned.
revision petition was allowed.
Yes, lordship.
Huh.
And it was preferred by the second party against the order dated 15/7/2023. Lordship may find it at page number 35. May I read, lordship? Case report put up today as per date fixed earlier. First party submitted attendance through his engaged learned counsel. Second party is absent without any steps. In the order dated 26/8/2021 passed by the learned subdivision and magistrate Hailagandhi. Also seen the judgment dated 25/5/2022 passed by the Honorable High Court. Heard the learned advocate of the first party member on this behalf and also seen the related documents present in the case record. It reveals that first party has been showing his presence before this court
since the date of submission of the Honorable High Court's order dated 25/5/2022, but the second party has been absent consecutively 4 numbers of dates fixed without any steps. Peruse the police report dated 23rd of July 2021 forwarded by the officer in charge Hailakandi Police Station that the obstruction created by the second party on the path, which is used by the family members of the first party school going children and other villagers, and at present they are facing many difficulties due to this illegal obstruction created by second party members, and as such there is very possibility of breach of peace and tranquility in the locality, and there is every possibility of group clashes between both the parties. Hence, considering the emergency situation, the officer in charge of Hailakandi Police Station is directed to execute the order dated 26/8/2021. Lordship may kindly see order dated 26 at page number 32, Your Lordship. Annexure 7, page number 32. So by the impugn order, which has been impugned in the revision, Lordship, in that order, the direction was made to execute the order dated 26/8/2021, which is at page number 32, Your Lordship. Married. Share taken up today as per returnable date fixed earlier. First party entered appearance through engaged learned advocate on their behalf. Second party, on the other hand, found absent. First party has submitted on oral prayer that the obstruction created by the second party on the path used by the family members of the first party by lawfully removed by using law enforcing agencies on behalf of district magistrate. Also peruse the police report forwarded by the OC Hailakandi PS, whereby it is also reported that the blocking of path has stopped the way of the family having school going children. Moreover, in emergency ambulance would not be able to proceed on the said path. This is in fact a serious breach of public safety. Therefore, I am inclined to order under section 133 of CRPC that OC Hailakandi will take immediate steps for removal of the obstruction on the said part. After receipt of this order, copy of this order be served to both the parties. So by virtue of the order dated 15/7, this order is to be executed. It was directed, Your Lordship. Now, Your Lordship, against that order, they have also preferred, second party also preferred a revision, Your Lordship, against which also came earlier also, came before this honorable court. This honorable court held that since it is an interlocutory order, revisional court has no jurisdiction to entertain. Even in this present impugn order is also an interlocutory order, Your Lordship. The learned session judge has no jurisdiction to entertain that petition, Your Lordship. Even on that, Your Lordship, I am using that path, Your Lordship, since along with the other villages, second party creating obstruction, and my grounds, Your Lordship, may find at page number 10, 9, 10, Your Lordship, of the petition. So at this stage, Lordship.
So their revision was allowed.
Their revision was allowed, Your Lordship, but it was allowed not conclusively, since it's an interlocutory order, matter because they were absent for 4 consecutive dates, order was passed. Admittedly, in that point of the view, Your Lordship, it is an ex parte order. But even then also, Your Lordship, the matter should have been remanded back to the learned additional district magistrate by the learned session judge. Instead of doing this, he has closed the. Lordship may kindly find at page number 43, Your Lordship. Last page, Your Lordship. Para 9. Accordingly, the impugn order dated 15/7 passed by the learned trial court is set aside, and thus the revision petition is allowed. Since the now, Lordship may kindly see page 41, para 8, Your Lordship. Page 41, para 8, Your Lordship. Admittedly, the impugn order is an interlocutory order, but however, so learned session judge held that the order was an interlocutory order, but at page number 42, paragraph 9, Your Lordship, it was held that it has been closed, Your Lordship. It should have been remanded back so that they entered their appearance. And earlier also, Your Lordship, this honorable court directed them to appear. Lordship may find that order at page number Annexure 6, page number 29, Your Lordship. Page number 30, last para, Your Lordship, relevant. Mr. M. Borbe, learned counsel for the bench submits that the impugn order is an interim order passed by the learned so-and-so in Miss case number so-and-so under section of the CRPC, and that no revision lies against the interim order, and therefore it is contended the impugn order dated so-and-so may be set aside, and the parties may be directed to appear for learned court. In view of the submission learned last para, Lordship, in view of the submissions of learned advocates of both sides and agreed upon by the parties, the impugn order dated so-and-so was passed by the learned session judge Hailagandhi in criminal stands set aside. The parties are directed to appear before. After that, Your Lordship, they did not turn up before the learned additional district magistrate, Your Lordship. This is how, Your Lordship, the order dated 15/7/2023 was passed in the Miss case, Your Lordship, against which the second party came before the learned district sessions judge, Your Lordship. Against that, this impugn order was passed, wherein it has been categorically held that this is an interlocutory order. Once it is been held that it is an interlocutory order, the matter should have been remanded back. It has been held, and another ground was that, Your Lordship, they were absent. It's not like ex parte order, Your Lordship. Matter should not have been closed, should have been remanded back. That second party should may be given an opportunity to be heard thereafter. But instead of doing that, Your Lordship, matter has been.
Okay, then yes.
And there is specific bar under section 397(2).
Bar to file a criminal revision petition against the interlocutory order.
Yes, Lordship.
It has been mentioned, so. Till returnable date, Lordship, also may be called for, so in the meantime, he may be protected.
I may be protected, Your Lordship.
What kind of protection?
Lordship, till the disposal of this petition, Your Lordship, I may allowed to use that part, Your Lordship, along with the others. Because they are creating obstruction, Your Lordship, using that part. I am not saying that the
Lordship,
operation.
at this stage, notice should go and LCR may be called for after receiving LCR, Lordship may decide.
I'm not on, my limited prayer is that, Your Lordship, I am not, operation of this judgment, I am not saying that it should be stopped, Your Lordship. Only this observation that till the disposal of this petition, I may be allowed to do that, but.
That will be otherwise.
This calls, Lordship, then again,
Because there is a specific direction and there is statutory bar under section 397 subclause 2, Your Lordship, they will entertain that. I may be allowed to use that part till the disposal of this. And let them come, the second party come.
Allowed to use will be with different situations then. Yes. Otherwise, you can point it out if any order is there, that much only. But allowed to use the part will be otherwise, what kind of order will be there only. Is there, now we have submitted that 35, page number 35 is the.
This is the order against which the second party preferred a revision, Your Lordship. And learned.
So what is the outcome of the revision? Revision outcome is that this obstruction may not be removed or whatever. That is the, so that can be stayed otherwise.
Yes.
It will help you.
Yes.
If it is stayed, suppose the operation of the whatever, rightly, wrongly, what is passed.
Yes,
if it can be stayed, then this force of the other 15/7 will be there then. That at best that can be. Otherwise, if I pass an order that you are allowed to obstruct it, then it will be, otherwise it will be disposal of the case only.
yes.
That is. Filed Mr. Ali Chaudhary, the learned counsel for the petition. Also filed Ms. S.H. Bora, the learned additional PP, appearing on behalf of state respondent. This is an application under section 528 of the NSS against the impugn judgment and order dated 16/2/2024, passed in criminal revision petition number 62/2023 by learned session judge Hailagandhi, whereby Revision petition, wherein the revision petition was allowed, which was filed against the order dated 15/7/2023 passed by Learned District Magistrate, directing for execution of the order passed earlier dated 26/8/2021. It was case number was
This case number 222M 2021.
222M
Yes.
222M/2021 under section 133 CRPC.
21 under section 133.
CRPC.
133 CRPC. Good stuff. Huh? Absolutely for issue notice. With the responses, no formal notice is required to be served on response number 1. Also call for the scan copy of the copy of the LCA. We call for till next date of listing. Let the order passed in criminal revision petition number 62/2023 dated
16/2020.
dated
16/2020.
16/2/2024 be state till next date of listing. Because list according. You take steps. Yes.
Obliged. The criminal petition was the joint petition filed by accused and informant both are jointly filed for was the Gopur police station case number 52/2024. This case is pending in appearance test. Let's say SDGM Gopur.
It's a case of 376 jointly. Yes, Goswami.
Okay. This 20 agreement.
Monastery Busumatra is the victim.
First petition number.
Charge sheet is already
Only
filed.
submitted. First sheet is 18 event details, just medical report, heart treatment, nothing else.
Pardon?
In first sheet, page number 18
One.
second paragraph is given details, heart statement, medical report, everything.
That is the issue notation in the case of 376. Sasilo is the
First sheet, okay. Both are married person, not husband and wife. Both are married.
They are married.
It is one
Have you annexed any other statement of the victim and all? 161, 164. Have you annexed? No.
Is that state of proceeding?
Notice.
Okay, we are staying the proceeding. We'll call for this scan for you. Same order, heard Mr. Algover, and also heard Mr. DP to submit in all the for the state respondent number 1. This is a joint application filed by the victim and the accused jointly for washing of the police. Now, why Gopur? It's already PR case is also registered.
Paragraph page 3, paragraph 1. Here it is.
For setting aside in washing of the FIR of Gopur Police Station case number 52/2024 and the entire criminal proceeding registered under PR case number 131/2024 under section 448, 376, 511, 325, 427, 506 IPC, which is pending before SDGM bracket of M Gopur Biswanath Child. Of Biswanath, sir. Issue notice করে দিব. No formal notice is required to be served on state respondent. Scan copy of the LCA be called for till receipt of the LCA or the next date of listing. Further proceeding in case number so and so pending before direct LGTM so and so be state. List accordingly after vacation.
Obliged.
Well,
yeah, please, my lord. Possible for pending, my lord.
একটু কানেক্ট করবো দিদি। এখানে আসানের রুটি মানুষজন খুঁজবো ইয়ার ফ্রম দি ইয়ার মানে কাউন্সিল জন আইটেম নাম্বার 3 কাউন্সিল আসানি ইয়ার খুঁজো সামান আছে আইটেম মানে এটা আছে কানেক্ট করবো কি করতেছে we are trying to connect this one item 13 matter still connection is there item 13 why don't you call item 13 we cannot help
Item 13.
yes
This is an application for quashing of the FIR and the charge sheet. Your Lordship, the matter is under section 120B, 420 and 406. The FIR is at page 17.
এটা এটা কোন রেকর্ড তুমি যাও কোন টু 13 কোন টু 12 এটা 13 লেখা এটা 12 করলে FI is that page
It's page 17, Your Lordship. And this case is completely of civil nature, and based on the extent of the FIR, the petitioner number 1 was being arrested, and he was granted bail on the very first day by the Honorable High Court because the case is of completely of civil nature, and CD was also not being called for. Now, the real fact of the case is that, Your Lordship, the petitioner, who is the accused number 1, is had a partnership business with the informant, and the petitioner number 1 is the license holder of a liquor shop, which is after dark, and they also had a partnership deed, which is annexed at page 31, Your Lordship. It is a partnership deed between the informant and the accused number 1, who is the petitioner number 2 in this case. And based on the same partnership deed was also being dissolved. And Lordship, later on, what happened? They refused to take the investment from the petitioner number 1. And after legal notice was being sent to the informant, later on, based on the legal notice, they have filed the FIR. In the legal notice, it has been very clearly stated in the legal notice, which is at page 38, Your Lordship. Page 38 is the legal notice prior to the filing of the FIR. It's clearly stated they amicably decided to dissolve the business, and thereby a proposal was made by the petitioner number 2 to the informant to purchase the license shop, but the same was refused and denied, and thereby asked the petitioner number 1 to return the investment in the farm, and accordingly she decided to sell the shop to the one Bijoyna, and the Bijoyna, she had also taken 5 lakhs in advance, and later again the informant came to the petitioner that she want to take the shop again, and the advance money was again returned to the Bijoyna. And taking the advantage of the same, she again given a market less than the market value price to the petitioner number 1. Then she again refused to sell it to the informant, and legal notice was sent in this regard. Now they have filed the FIR based on the false facts, and they could have filed a civil case for the money suit, because it is completely of civil nature. They have instead filed an FIR to harass the petitioner, Your Lordship. And the case has been succeeded, and now it is in the appearance stage in the Chief Judicial Magistrate Court, Hailakandi. So my humble prayer, Your Lordship, may call for the case record, Your Lordship, and the matter may be stayed for the timing, Your Lordship, because it is completely a concocted story. The prior legal notice was being sent to the informant, and instead of replying to the same, they have filed an FIR based on the false facts. This is only call for record toxic after procedural record toxic, because on 19th of December the case is fixed for appearance, Your Lordship, and for no reason they should appear in this case, because they have been falsely harassed in this case. Accused petitioner number 1 also was behind the bar based on the only the strength of the FIR, and the Honorable High Court was pleased to grant bail without even calling for the CD, because it is completely of civil nature. I have annexed the order also. Hearing. Case is already charge seated. Yes, it may be charged. We have come for the crossing of the same, your lordship. So, LCA may be called for. He may be the case may be stayed for the time being, your lordship. At least the disposal of the case here, because he's only in the appearance stage.
You are Mr.
Yes, Ahmed.
Heard Mr. S. Ahmed, the learned also for the petitioner. We also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. An application, section 5, the 28 of BNSS for washing the FIR and the charge sheet in connection with the PS case number 117 of 2024, under section 120B, 520, 406, IPC. Issue notice to the respondents to register DD and as usual process. No formal notice is required to be served on respondent number 1. Also call for discount for POSCO. Next part. By Mr. Ahmed on the interim plan. It is submitted by him that the entire case is of civil in nature, and the dispute arose only when the petitioner had issued a legal notice to the respondent, and after receiving the legal notice from the respondent, they have filed an concocted case against the present petitioner with some false allegation, which is false allegations, which are also civil in nature. Accordingly, submitted that prayed for the stay of the order, stay of the further prosecution till disposal of the present petition. Next point, Mr. Goswami submitted in this report that case has already been charged and hence, without any stay, till the case record may be called for. Next point, hearing this submission made by Learned Counsel for both sides. Let the further proceeding in case number, which is
PRC case number 590/24. Judicial miss.
you have not mentioned here.
In the prayer portion, it has been mentioned there.
Further proceeding in PRC case number 590 of 2024 be stayed. Where it is pending?
In Chief Judicial Magistrate, Hailakandi.
Pending before Chief Judicial Magistrate Hailakandi till next date of listing. List accordingly after 4 weeks.
Much obliged.
Take the instruction on that case, Lordship. Yes, I have received the instruction, Lordship. Lordship, we have received the case on 29/11, and last note of the IO is 27/11. He was sent to the judicial custody on 4/12. 4/12/2024, Lordship. And Lordship, the case was before the Lordship on 6/12. On that day when the case was prepared, that in the medical, Lordship. Now he is in jail.
Okay, we'll take the written instruction for report.
We have communicated with him, the IO and OC also.
Okay, we are fixing it in 17 or 18 something. I passed the order. So that report can be called for. Forwarding is not available. Nothing is available because in report. Who's it? Connection home?
Item 7.
No, it connection home. 3-2.
Item 7.
Please, Your Lordship. It's a revision petition, very limited sphere and in very difficult circumstances I have come. My conduct is not very good yet, my lord. I will kindly come to page 14.
1-4.
1-4, my lord. Page 45, annexure 14, my lord. Page 45. This was a POSCO case, my lord, under section 8 of the POSCO Act. Case was fixed for defense evidence, my lord. I adduced the evidence of one witness, my lord, and for the second witness, I had been taken multiple adjournments. Now, page 45 is the impugn order. On 30/11/2024, my lord, I had again paid for adjournment, but considering the fact that I had also taken adjournments on multiple occasions in the past, the learned trial court rejected my prayer, my lord, and fixed the case for argument tomorrow. My limited prayer is that, my lord, this witness which I intend to examine is my wife. She is a vital witness because the nature of the case is such that her evidence is very important, which will actually show the real facts of the case. Now, I cannot defend my conduct, my lord. My conduct is bad. That is true, my lord. I have taken multiple adjournments. In this case, my lord, I had taken around 16 adjournments on my part. Court had adjourned the matter once when the witness was present, and on one occasion, the special PP took adjournment. But majority of the adjournment, the stage of defense evidence, were on my part. That is not in dispute, my lord. Now, I'm only seeking one opportunity, my lord, to adduce this evidence on condition that I will not take any more adjournment, my lord. That one witness may be allowed to be taken, my lord. That is my limited fear. If my lord, my learned friend does not object, case is fixed tomorrow. Even if your lordship directs, we will adduce that evidence tomorrow.
Heard Mr. S. Thomas, you are on the counsel for the petition. Also heard Mr. B. Goswami, the learned additional PP appearing on behalf of state respondent. Otherwise, other order sheets we have annexed or?
We have annexed everything, well, all the orders, we are not. From my lord, will kindly see page 23. Page 23 is the order, my lord, whereby statement defense was recorded, my lord. Thereafter, case has been fixed for defense witness, my lord. 24/7, I took adjournment. 17/8, I took adjournment, my lord. Thereafter, my lord, at page 26, this time, my lord, witness was present, then.
When witness was present?
On 7/9, page 26. Witness was present, my lord. On that day, on the prayer of the special PP, my lord, case was adjourned. Subsequently, my lord, again, I kept on taking adjournment. And eventually, my lord, on again on 19/7/2024, page 32, my lord. The witness was present, and this time the court did not examine the witness. Finally, at page 39, this witness was examined. Thereafter, another witness, on that day, I prayed for another date for examining another witness, Shahira Khatun, my wife. Thereafter, again, I took adjournment on 4 dates, my lord.
It's an application in section 438, plus 442, read section 520 of the BNS. For setting aside and quashing of the been order dated 30/11/2024. In special bracket of P of 14 bracket A of 2019. By and passed by learned special judge Lord Salmara of Ayapuri. POSCO. Next point, it is submitted by Mr. Nawaz, learned counsel for the petition, that it is a fact that on several occasions, the petitioner took adjournment when the case was listed for evidence, defense evidence, and however, on 2 occasions, the witness was one witness was present, but due to some difficulty on the part of the court, and on 1 occasion for the adjournment prayed by the prosecution, the witness could not be examined. However, the witness was finally examined on when?
On 17/8/24.
17/8/24, and thereafter he prayed to examine one more witnesses, who is the wife of the present petitioner and is the vital witness of the prosecution. However, the prayer was allowed. It is also affected on 4 consecutive days. He again took adjournment due to some personal difficulty, and accordingly, the learned special judge had passed the order on 30/11/2024. Rejecting the prayer for the defense evidence, and case was fixed for argument. The DW was closed and case was fixed for argument. Mr. Nawaz further submitted that the case is fixed tomorrow for argument, and the witness who is to be examined, who was supposed to be examined by as a defense witness, is a very vital witness for the defense, and she is the wife of the present petitioner. Accordingly, he prayed that one more chance may be given to adduce the evidence of one DW, and if required, he is ready to produce the witness on 10/12/2024, the date fixed for argument. Next, Mr. Goswami, the learned additional PP submitted that though the conduct of the petitioner is not satisfactory, however, or the insubstantial, however, one more chance may be given to the petitioner to adduce one more defense evidence as posted. Next, hearing the submission made by learned counsel for both sides and on perusal of the case record and the annexures filed along with the petitions, it is seen that the conduct of the petitioner is not satisfactory, and he took several adjournments which delayed the disposal of the case, which is registered under POSCO.
Section 8 of the POSCO.
Which is registered under Section 8 of the POSCO Act. However, considering the submission made by the learning counsel for both sides and also for the use of justice, this court is of opinion that one more chance may be given to the defense, to the petitioner to adduce his defense evidence first. As the case is fixed on 10/12/2024, the petitioner is hereby directed to produce the defense evidence on 10/12/2024 itself. And the learned special judge will accordingly record the evidence of the DW with the observation. And if it will allow credible with the observation, the stand is posted.
One prayer, madam, the order may be uploaded today so that we can at least give a soft copy.
Okay.
Deeply obliged.
Seven. ये तो कलेक्शन हुआ है ऑपरेटर 3 हुआ है This nature of this
POSCO is there.
POSCO then, and PW1 is the victim.
PW1 lordship, I have annex. Yes, lordship, PW1 is there.
Then how can I say it is all? It's a act itself space that you cannot bring the victim or the minor one and again before the court for repeated hearing. It's not allowed. It's not. I mean, it cannot be allowed unless there is a very
For the end of justice, lordship.
No, we can pass only the order. You can file a fresh petition
With a
results.
lordship.
That may be only. Otherwise, too, we don't think anything is there.
And that may be considered by that time.
Or Mr. M. Khan, the learned 9 item. M. Khan, the learned counsel for the petition. Also heard MS SH Bora, the learned additional PP. So this is an application under section 528 of the NSS against the imprint order dated 4/11/2024 filed by learned special judge Bongaigaon in special plea case number 62M/2023. It is submitted by Mr. Khan that what is the reason why do you want to cross-examine those witnesses?
Some vital lordship.
Omission was there.
Lordship.
Submitted by Mr. Khan that out of 10 numbers of witnesses are there. Out of 10 numbers of witnesses, 5 has already been examined and cross-examined. However, due to inadvertent omission, some vital points were left to be cross-examined to the witness number 1, 2, 3, and 4. Accordingly, a petition was filed before the learned special judge for recross of PW 1, 2, 3, and 4, but the same was rejected by the learned special judge by order dated 4/11/2024 and 4/11/2024, and for which the present petition has to be filed by the petition. Mr. Khan further submitted that the one more chance may be given to the present petitioner to cross-examine the PW 1, 2, 3, and 4 as some vital points are left to be cross-examined, which is necessary for proper adjudication of the matter. Next paragraph, Ms. Bora, the learned edison PP submitted in this record that this is a POSCO case and there is no such ground mentioned in the petition for recalling of cross-examination of those PWs. And accordingly, the learned special judge rightly passed the order of rejection dated 4/11/2024. Next paragraph. After hearing the submission made by learned counsel for both sides, I have also perused his record and annexures filed along with the petitions. It is seen that the petition for recross examination of PW 1, 2, 3, and 4 was filed under section 311 CRPC on we received after closure of 5 numbers of PWs, but it is rightly observed by the learned special judge as that there is no special ground mentioned in the petition for recross of PW 1, 2, 3, and 4, and accordingly, I do not find any irregularity or illegality in the order passed by the learned special judge dated 4/11/2024. However, considering the submission made by the learned counsel for both sides, the learned counsel for the petitioner and also for the answer of the justice, it is hereby directed that the petitioner may approach the learned special judge so and so with a fresh application citing the grounds for recross examination of PW 1, 2, and 3, 1, 2, 3, and 4, and also to disclose the points which are not like so and so, and the learned special judge may pass the order accordingly will pass the order accordingly in accordance with law. But
Yes.
With the observation is just disposed of. When the next date is fixed on?
4/1/25.
Petition from next date total is you filed your petition before 4/1.
Item 48.
Yes, please, your lordship.
Oh, yes.
Lordship, the interim order is 27/7/2022. Admittedly, Lordship, default on the part of the petitioner due to some compelling circumstances, as his father was seriously ill and he was under constant treatment at GNRC. Those papers I have submitted, Lordship. Lordship would be, before that, Lordship would be pleased to see the FIR at page 10. Here. Lordship, with utmost respect, I submit so approximately so and so I was transporting iron doors, so and so tag bearing registration number, and my was therefore intercepted my vehicle. Blocked your garden, so and so blocking the road and auto vehicle. They obstructed my truck, broke the glass window, and forcibly pulled. Subsequently, they assaulted me and took away driving license, Aadhaar card, and 4,000. Managed to escape and save my life. This was the allegation, and this lordship will be fine to find the sections at page 12, registered 143, 341, 427, 325, 371. Subsequently, pursuant to the lodging of this FIR, lordship, petitioner was taken into custody and he was released on bail. But thereafter, lordship, even though he was in the initial period, he has appeared, but as I have mentioned that lordship, due to his compelling circumstance, he could not appear. Now, lordship, the next date in the trial would fixed on 7th of January, lordship. He is willing to participate in the trial, and that is why before your lordship, may I pray, lordship, the execution of warrant may be kindly kept in abeyance till his appearance, and he will file regular bail. That is my prayer, Lordship.
You have annexed the order from 27/7/2022. Earlier order was also annexed or no?
No, Lordship. Page 13 is the 27/7, the initial order and subsequent dates, Lordship. This is the initial order of NBWA and the subsequent dates.
Name of your petitioner is?
Nazrul Ali.
Nazrul.
Nazrul Ali. Pending before Learned Additional Session Judge, FTC, Dorong Mongoldoi Lordship. I have mentioned in the cost title.
Yes. Lord.
Otherwise, on several occasions, he is found to be absent.
Yes, since 2022 only. Since last more than 2 years.
Yes. Where is the next date fixed?
7th January.
Will the order be amended?
No.
That order is not annexed.
Well, a PNA is also issued here. Because you have annexed the order till. Yes. Thereafter, your order is not here.
Lordship, 24/7, yes, and 24/7, 26/9, 26/9, 24 was again fixed for appearance. Page 26 will reveal that, Lordship. Same order has been passed on that day.
Oh, that's what I'm saying.
Yes, no,
26/9 is the next last
No
one.
PNA, Lordship.
What is the subsequent development after 2000?
Same Lordship, same thing as, same order was fixed, fixing 7th.
From where you're seeing?
That I have instructed Lordship. 7th is the date fix.
No, 7th is the this is where from we are saying. Same status is there only.
Yes, Lordship.
Yeah, next week.
Really one lack of stamp status. Heard against D. Som, the learned counsel for the petition. And also heard against SH Bora, learned additional PP appearing on behalf of state respondent. This is an application, but can you so and so, so and so. It is submitted by MS Som that the accused petitioner was arrested in connection with this case and he was granted bail. But after filing of the charge sheet, he was not aware about the pendency of the case and hence he could not appear before the learned court below. She further submitted that what is the reason? DNRC for whom? For father.
Father's
He
statement.
was also had to remain busy with the treatment of his father, who was admitted in the GNRC for a considerable period. For this way and so. Accordingly, considering his absence, the learned additional session judge FTC Dorong Mongoldoi had issued NBWA against him on 27/07/2022 and the other subsequent dates. However, he is ready and willing to appear before the learned trial court below and to contest the case. If the NBWA issued against him the state of suspended, giving an interim protection to the present petition. MSSH Pora, the learned edition PP submitted in this regard that for a considerable period, that is more than 2 years, the accused petitioner was absconding and avoiding the arrest. However, however, he may be given a chance to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. 7-1 is the fixed date.
Yes, Lordship.
7-1 is the fixed date for appearances.
Till then, Lordship. Till seven.
Till then, your NBW is state of
Excellent.
suspended.
I'm deeply obliged.
Dispose of.
Item 3.
Please, your lordship.
Oh, you were there. Yes, yes.
Yeah,
Where
I'm-
are you present?
At Allahabad, lordship, Allahabad High Court.
Allahabad High Court.
Lordship. There is a matter going on for the last, only on Monday, lordship, it is being listed.
Okay.
So, lordship,
Yes.
here the matter is, lordship, regarding, here brief facts of the case is that, lordship, initially, it's CGM, while going, so CGM has convicted us for 1 year, and we have approached the appellate court, and appellate court upheld the order of the CGM court. Lordship, here, it is the date occurred, the victim died due to the electrification, lordship. Electrification of a wire, lordship. It is a purely on circumstantial evidence, lordship. Here, we may rely on in the later stage, lordship. Here the revision petition is because, lordship, we have availed all the legal remedy. We don't have any other remedy, lordship. First appeal is being upheld, lordship, because we approach the session judge court. Second judge upheld the CGM. So CGM order, lordship. So we are for this revision, lordship, staying the order of the appellate court,
Under which
lordship.
section you
The
got
session judge
convicted?
court, lordship. Here we
304A. You convicted
304A,
under
lordship. 1 year,
304A.
lordship.
No, you are
So we
convicted
have,
under
I
304.
will, yeah, lordship, yes, lordship. So, lordship, at this stage, lordship, I will, the whole case is on circumstantial evidence, lordship. But that part is not prosecution. I will place, lordship, in the later part, lordship, that prosecution could not prove the stain, lordship. That the possession part, nothing. Prosecution, the conviction was based on the witnesses of us, lordship. But before that, there is no chain of events, lordship. The chain of events is not being proved, lordship, because it was circumstantial. Nobody has seen how he died, lordship. So at this stage, lordship, I'm only praying that the notice may be issued, lordship, and the order passed by the appellate court may be stayed, lordship. We are not being arrested, lordship, as of now.
You are still on
During the limitation
previous
period, I
bail?
filed it.
You are still on previous bail?
Yes, lordship.
You are still on previous bail?
Yes, lordship, I'm still on previous bill, lordship.
Are Mr. P. Sharma, the learned counsel for the petitioner, and also heard MSSH Bora, learned additional PP, so and so. Okay, what is an application under section 438, 420, 442, BNSS, read with section 528 of BNSS. Against the judgment and order dated 24/7/2024 passed by Learned Session Judge Baksa in criminal appeal number 07 of 2023. Upholding the judgment and order dated 30/06/2023 passed by Learned Additional CG Baksa in connection with PRC case number 749 of 2019, convicting the accused petitioner under section 304A IPC and sentenced to undergo RI for 1 year and to pay a fine of ₹5,000 in default SI for 3 months. Issue notice to the respondent to register the managerial process. No formal notice is required to be served on respondent number 1, state respondent number 1. Also call for the LCR. Further, considering the submission made by learning council for both sides, let the execution of imprint or execution of sentence passed by imprint which has been an order dated so and so by criminal appeal number so and so, upholding the so and so, the state till the disposal of the connected revision petition and also the petition. Oh, yeah, I is there, na?
Annexing one judgment. Additional, annex a judgment in order dated 36/2023.
The judgment of appellate court. I did it. If I appeal, then otherwise what to do? Appeal can be admitted? Oh, appeal, no, sorry, it's a revision, na?
Revision.
Revision of simple order লিখক, issue notice করে দিব। List accordingly after 4 weeks কইলে আর ইয়াতে আপনি in I8 করে দিব, so and so করে দিব। Stay and he allowed to remain on previous bail till the disposal of the connected criminal prison. With above observation, I stands disposed. Call for the LCR, it will do.
Highly obliged, Lordship.
Okay.
Highly obliged. Highly obliged, Lord.
Okay, yes, yes. Okay.
Item 43, bail hearing.
One moment. I think. M. Khan was there earlier moment. It's not here now.
After some time, madam.
After time, sometime.
Also, he's also in legs in some other court.
Oh, who is MICS? MS or MK Brown?
At 2 file.
After some time.
34.
Actually, kindly have a look at the last order, madam. 212 possibly, madam.
Yes, I have received the case there.
Case there is not received, my lord. Today morning also we have, my lord, contacted the concerned police station, my lord. We have been informed that, my lord, the IO he is on leave, my lord. That is why, my lord, the diary could not be forwarded.
Well, last occasion.
Then what to say, you see? So fixing the case diary for.
Is the 4 days possibly, madam?
Now it was first order was passed on 24/10/2024.
Thereafter 13.
Then 13/11.
Then 26.
Again 26/11 and on last 2/12.
Yeah, because it was last occasion, it was informed, my lord, that it was pending in the sessions court, my lord. Last
No,
order.
session court, I mean not.
Sorry,
Sorry, in fact, Sunil.
Yes, yes, madam. So last occasion, that was the, my lord,
Yes,
instruction.
yes,
So now, my lord, again, they are stating, because why I am stating, my lord, otherwise definitely NDPS case, my lord. Here, nothing was recovered, my lord, because the first incident, my lord, it took place on a different date, that is on 15/7, my lord, and specifically from 4% it was recovered, my lord. And there is no allegation that there are other person. They also did not say that we got it from so and so. Thereafter, my lord, these accused petitioners, they were arrested on 16/7, my lord. Oh, sorry, my lord, 9/8, my lord. 9/8, from 15/7 till 9/8, my lord, kindly see. Different people, different vehicle, and they have been entangled in the instant case. That's why we have been praying, my lord. Because here.
See, if they are not at all connected, that is different thing, but if you go by this section, there is a one section is added, that is 29.
That is true.
29, I don't know.
That is true.
But if it is not there, I don't know what is the investigation or why he has been implicated.
Yes, yes.
So for that only CD.
Yes, yes, I'm not on that. I'm only on the merit why submitting, because
Yes,
otherwise normally, my lord, NDPS case, we also wait, my lord, that But here, my lord, because he has to pay, that diary has to be there, my lord, your 1.5 months has gone.
Then what is your submission now? What to do?
Some more time may be granted, my lord, to produce the case diary. I pray to my lord, fix the date before vacation, my lord, subject to my lord, confidence of this honorable.
They'll, with all respect, they are, in that case, my lord, the earlier order, my lord, because there is a specific, my lord, direction and observation of this honorable court, my lord.
Yeah, obviously, you are saying that you're basically insisting on merit, in fact.
Yes,
As you have submitted,
So
that is
that-
true, but there may not be any thing to, I mean, for the accused person against, there may not be any there.
Yes, yes.
But the we are now what to do, because CD is there. Now, can it be on fixed on 17th or 18th? Otherwise, we don't have any days, but what to do?
My lord, diary for
19.
For sending diary, my lord, whether the presence of the investigating officer is necessary, my lord, that is to be seen, because
No,
diary-
he is holding the case diary.
he cannot take it home, my lord.
No.
Because
Home is not there.
Last occasion, kindly say, last occasion, he submitted that it was in the sessions court.
Yes.
So now, my lord, there another chapter has come that he is on leave or something like that, my lord. That cannot be, because diary, my lord, and triplicate diaries have to be there, my lord. Now, my lord, diary, my lord, he cannot take it home, my lord. Diary will be the OC or whoever in charge of that police station, my lord. We are not stating
No,
that.
we are not sure now whether still in the court of the session, or they have already, it is in the police station. That is not confirmed.
That is true, my lord. But here, my lord, specific direction of this court, my lord, that has been flouted, my lord. How can it be, my lord? Lordship has to be strict in this sense, my lord. Otherwise, we would not have prayed, my lord. But in this sort of cases, stringent provision, misuse of it, my lord, as per our understanding, my lord. And now diary repeatedly, this is the third, fourth time, my lord. That is my humble submission before Lordship, my lord. And because there is a specific order from this honorable court, that's why, my lord. Let him, because it is from Tasteful, it will take 3, 4, 5, 4 hours time, my lord, from Guwahati, my lord. From Tasteful, my lord. Sonitpur, my lord, Tasteful police station. They are inside from 9, 8, my lord. Harima. Aji? 9, 8, Aji. Oh.
Okay, then we are issuing so-called notice then.
One more chance may be granted, my lord. If he fails, my lord, then my lord, I leave it to those.
Why he is soft to the investigating officer, I don't know, my lord. Because diary, we are just seeking the diary, my lord. Thereafter, if their material, lordship reject it, my lord. Your high court, my lord, passing order repeatedly 3, 4 times, my lord. Rest I leave it to your lordship, my lord.
Because my lord, he has forwarded a my lord, intimation that my lord diary could not be forwarded, my lord. That is why I'm paying, my lord. If he has not forwarded any intimation, my lord, then my lord, I leave it to your lordship, my lord.
He is saying that he is on leave.
My lord, IO is on leave, my lord.
Well, I'm not repeating, my lord. Diary he cannot take, my lord.
Mr. E. Chaudhary, the learned counsel for the petition, also heard Mr. R.J. Borwa, the learned additional PP appearing on behalf of its respondent. First of it is submitted by Mr. Borwa, the additional PP, that the IO could not produce, the diary could not be produced before the court today, as it was informed that IO is on leave and he could not procure, and he could not send the case diary to this court today. Mr. Chaudhary submitted in this regard that if I was on leave, the other officer who is in police station could have sent the case diary, and I was not supposed to take the case diary to his home. Poster. Next para. From the record, it reveals that on several occasions the city was called for, and I was not in a position to furnish the same. However, considering the information received by the learned additional PP, last chance. No. The city produce court in default, he will be served with a personal so-called notice. For considering your prayer only I have considered.
My lord.
For one more chance is only 19th, you are saying.
My lord, 18, my lord.
18th.
Can it be preponed, my lord? Kindly, my lord.
18th.
It will be last month.
The preponding will not help you, I think. That's why I'm saying
It is not stated that he will be on leave for how many days, my lord.
18th.
Kindly let it be little bit, 15th or 16th, and otherwise my last.
Not possible. 15 or 16 may not come, may not reach in fact. Let it be on 18th. We'll pass the order.
Copy of the order maybe, Malo.
Acha. Copy of the order. Oh, it not order. You just want the order, copy of the order.
But then 17th, my one, because 2 days only holidays will be, that's why, otherwise. On
2 days
17th,
holidays?
18 or 19, my lord, after it will be holiday, that's why. On 17th, my lord.
The 20 is our last court, man.
20 no, 20 only by one.
20 February. 20 February, the possession to have.
20 is our last working day. Let it be 18th only. 18th.
Obliging. You have the forces. 35.
May please, your lordship. One of the petitioner behind the bars since 81 days, my lord. In this case, my lord, all the accused person already listed on bail by the Supreme Court, my lord. The case is that, my lord, on my lord, 9/9/2024, eviction process was going on in Procedural, my lord. In the affair said that about 2,000 people and prevent them, my lord. And somebody building a stone and allegation here that Lathi Thala, they have come and attacked them. In fact, my lord, the present petitioner, the single petitioner, as per my instruction, my lord, he is saying that he lately reached the place and his house also evicted, my lord, and they are the victim now. My lord. The family are, my lord, moving hither and thither. Very pathetic situation, my lord. He is in jail, minor children and wives, they are moving, my lord, in different places. So it's 81 days, my lord. And from the same forwarding, other requests already listed on data. I am praying for same relief, man.
In this case, my lord, lordship is already aware, my lord. Several accused person, my lord, they attacked him, police, my lord. And my lord, the investigation is pending, my lord, basically, my lord, to collect the injury report, my lord. Otherwise, my lord, the accused persons were arrested, my lord. Investigation sufficiently progressed. But my lord,
Injury report, some of the injury reports have received.
some of the injury report received, but some are yet to be obtained from my lord, GMCs, my lord. For that purpose, my lord, the investigation is pending, my lord.
Thank you. Thank you, sir.
By the
81 days, they have got bill on 26/11. 15 days back, they have this from the same forwarding also. Any terms condition, madam. There is the.
He is also one of the accused person, my lord, who is involved, my lord.
While, my lord,
in
2,000
object
people,
offense, along with others, my lord.
2,000 people, my lord, was present. And it was something happened, that's admitted fact, but individually, he has no role, man. But he was present and subsequently came. So say 81 days, my lord, but my lord, other requests already listed on bail, my lord. Same forwarding also, my lord, two accused person came, 15 days back, they have reached. And very pathetic situation. Family are moving, no shelter. Government also not given, my lord, any settlement of them.
No, for that reason, my lord, they can attack the, my lord, district administration, my lord. Basically, the, my lord, police officer, my lord, who is, my lord, maintain law and order situation in the state, my lord.
In the affair, my lord, some access they have.
That was a situation, in fact.
Yes, my lord. And there are, my lord, several other situations, my lord, where, my lord, this accused person, my lord, they are organized, my lord, and they even set a place in my lord, police station also. There are similar situations like this also. This accused person, my lord, granted bail, my lord, because he would again, my lord,
Who already
witnesses.
more than 14% from similar city, they have released on bail 15 days back. Today is, my lord, 81 days. Someone maybe consider individual, one single person here. 81 days, so what will be remain, my lord, now? Only 9 days left.
Even this consider কৰি খালি দি দিব অলপমান লিখিব they are innocent আৰু বৰুৱাৰ submission অলপ লিখি দিব that there are some objection I'll record. There are injury reports are yet to come, some of
Some of the injury report is, but some are yet to be collected from the, my lord, GMCs.
some are yet to be collected from the GMCH. And considering the nature of offense, he raised objection and submitted that it is not a fit case to enlarge the accused persons on bail, only considering the act of detention. And submitted accordingly. But more or less only without going by the merit of the case, only on the. This is pending before whom?
Well, CGM Kamrup Metro Man.
CGM Kamrup Metro.
Yes.
CGM Kamrup to the satisfaction of CGM Kamrup. Okay, on the ground of length of detention only, we are enlarging, not on merit. Huh?
Yes, ma'am.
$19,900 হলে কি মান দিন? And in 10-31 days are November 30 days. December আজকে কি মান তারিখ? Today is 9th. Oh, 81 days. $81 days behind the bar.
CGM Kamrup Metro.
CGM.
I'm obliged.
36.
Yes.
Average space 10.
Page 10.
10. In this case, section 15 box is there. Should you already received?
In this case, my lord, we have tried to obtain information, my lord, from the police station regarding service, my lord. So we have been informed that they have not received this copy of the notice, my lord. And I'm going to serve them on information.
But your office has already received.
Yeah, we have provided, my lord, but they have not received, my lord. That is what we have been informed, my lord, today.
Then what to do?
Well, I'll do one thing, my lord. I'll take the, my lord, the notice is available in the, my lord, case record, my lord. So we'll, my lord, to make a xerox copy, my lord, then we'll again forward it to the, my lord, Portal police station. And let the matter come up on Friday, my lord.
No, after 16 minutes.
Huh?
After 16 minutes. I'm not available.
Not be available.
For 60. 17, my lord.
17 will do. Heard Mr. Swensu, the counsel for the petitioner, and also heard Mr. Swensu, the learned additional PP. It is submitted by Mr. Purva, the learned additional PP, that on inquiry, it is informed by the police station that they have not received the notice on the respond number 2 yet. With context, he submitted that he will forward the notice to the judicial police station again to serve on respond number 2 and accordingly paid some more time for the same. List the matter accordingly on 17th, on 17th, enabling the learned additional PP to take instructions and to send the this notice to the respond number 17th.
Publish.
Yeah, please, my lord. 37. TD was called. 37, my lord, case there is not received today. POSCO matter. The third court officer, my lord.
Mr. Forecaster was there earlier. You are appearing. Earlier also case was fixed for.
My lord, 3-4 officer, my lord. Interim was also not granted, my lord.
It's a POSCO, how can interim be granted? It cannot be. POSCO, which section?
Section
Section 8.
6.
6 of the POSCO. Oh my goodness. 6 of the POSCO, you are coming for AB. Anyway.
Lakshmipur, PSC 39.
It has to come from which district?
Not Lakshmipur.
Not Lakhimpur.
My lord.
Have you got any information regarding that? Because reminder was issued on the last occasion also.
At 2 then, my lord. At 2 PM, my lord, why the case there is not now. Oh, Lordship may fix it, my lord, sort that, my lord.
Short day is the problem.
No time, my lord.
No time at all. We don't have. It's a AB only, we can list immediately after vacation also. Because he is absconding since 6 of POSCO and he is absconding from the CD case record itself. Case was put up on 27/9. That means around 2.5 months he is still absconding. So another 15-20 days he will abscond. Isn't it? It will let it come after vacation only. Issue reminder after vacation. However, you take instructions and on the next date of listing, it should be reached before us. We are fixing a date also. Yes, when it can be fixed then.
8 or 9.
8 or 9 will do, Mr. Or you need a shorter date.
Madam. 8 or 9. Yeah, I will get mad.
Okay, 8. 8 we are fixing.
My lord.
8 of January.
Yeah, please.
Yes.
CD was.
30 of the case there is no precedent.
CD has been sent to my information.
Sent.
CD is here, I have. Have you also taken up with it?
My lord, if my lord not finished it.
No, because I have asked my client, you go and inquire whether CD has been sent or not. OCS said that we have sent it.
My lord, at 2 PM then.
Okay, then at 2 PM.
Otherwise, I have got no. Because
No, if your CD is there, definitely will perish the CD. It's no bad at all.
no, yes, madam, actually.
If you have already got the instruction that CD is has received, then it's okay. We're fixing it on 2 PM.
At 2.
Okay.
Admission.
No, just a second. And Han was there, I think. One matter was adjourned, not that time. Bail hearing matter.
Bail and fix it, my lord, after some time, my lord. At 2 PM, my lord.
Other one.
33.
Which was the number?
33, my lord.
33.
At 2 PM, my lord.
With his lordship at 2 p.m.
You want to fix it at 2 PM?
2 p.m.
Okay. Yes, madam. What is happening?
Item 24.
24. Yes.
Lordship, for timing, my senior is leg and another court.
There are timing matters and at 2, there are 3, 4 matters are already there. So I don't know, it may not reach also. You want to fix it or timing? Okay. Timing ke bata hui gise de silo. Okay.
$25.
Lordship, kindly allow us times and timing. Senior will be appearing.
Ela pisot mati thaki ba ekdam na mati boi liya. Sachi hai.
Like.
Timing like ekbar pisot mati.
$26. Let me the last. So this appeal is lordship against the order of conviction whereby lordship learned session judge convicted this appellant under section 324 and 307.
324, 307.
Lordship.
First, you will find a conviction for at page 62. 6 months Lordship under section 324 and 2 years under section 307.
Okay, 25.
26.
For 324, 6 months.
Lordship, 6 months, and 307 Lordship 2 years.
307, 2 years.
Only 2 years Lordship. Lesser punishment was imposed.
Huh?
Lesser punishment was imposed considering the facts of the case. Lordship.
What is the lesser punishment?
No,
Here?
Lordship, actually it should be minimum 7 years Lordship, 307.
Yes.
But court has convicted only 2 years. That is why I'm saying court has
Minimum
noted
is
that
not
lesser
2
punishment.
years. Minimum is not 2 years. That's why I'm saying.
Yes, Lordship.
Who passed the order?
Session
PK,
Judge Lordship
Mr.
too.
Kalita. How early? Borwa?
Definitely.
Obviously, for 24 also, 6 months should not be, and then
Actually, Lordship, the facts of the case is that Lordship some enmity between
because now it's a
Yes.
very true fact that the 307 is
Yes,
very difficult to prove, in fact.
Lordship.
For convicting a person under 307 is very difficult.
Difficult Lordship. 324 is there Lordship, but 325 6 months has been given. I think Lordship may admit this appeal. Lordship.
Stepped on the right side of the abdomen. Acha, right side of the abdomen.
Yes.
It was stab injury, na?
As per the person our defense is that Lordship, he fall down in the rod Lordship and he got injured. Yes.
Okay.
And that is established Lordship.
Rod was there.
Yes, Lordship. Nearby the road,
And-
drainage system was there and open rod was there.
Okay. So we can admit this one?
Yes, my appeal may be admitted. Madam.
Yes. Why is the IF on?
I follow suspension of the sentence.
Anything you want to submit, Mr.
2 months Lordship, 6 months Lordship, he is already previous paid. That may be considered.
Okay, it will be considered from your side anything, or otherwise it will be considered.
If it is a new case, my lord, then my lord, maybe previous bail, my lord. Or-
Previous base. We'll apply for previous.
You are still on previous
Yes,
bill, I think.
already allowed.
It's a case of 2017 now.
2017.
17, my lord.
Appeal.
That will be true.
No, Lordship, judgment was passed in 2020. Judgment of 2024. Lordship.
Judgment is of 2024.
Judgment of bill 24.
Oh, then it's okay.
Within time that you have filed.
That part I leave it to rules.
আমি কোনটো আছো
No, you can
28 26 নামটো দেখোন না your name is not here na?
Lordship, the Okat number is there, Lordship, but inadvertently, Lordship, my name is not reflected. One K Devi's name is also there, his name is, her name has also.
KDB is also not here.
Yes, Lordship. My name is no Okat number.
Heard Mr. J. Kalita did not counsel for the petition. And also heard the answer. Appeal to admit Kuribo, no issue. Call for DLCO. First date of life. Call for DLCO. And it's after 4 weeks. This one, criminal appeal. I is for I is suspension of sentence. Penso prohibido. Somebody issue notice no formal notice is required prohibido. Do it at it. Stay has already appeared. Submitted by Mr. Kalita that the present accused petitioner is already allowed to remain on his previous bail. By the way, have you annexed the order that you are allowed to remain on previous bail?
Lodge, that order also I have not, but impugn order I have an expense.
Impugn order?
Lodge.
Where is the order?
Impugn order also I have an in the I also.
Huh?
But there's previous bill order that I have not an expense.
Or whether any, I mean, NBW, etc. was issued, that's what I'm,
That may be reflected in your order, Lordship. If such kind of notice warrant has been issued, then that will consider by the court. But so far my instruction is concerned, Lordship, that he is on previous bill.
sometimes it reflects in the judgment itself also. Is there any reflection? No.
No, Lord.
On the page number 63, my lord, issue jail warrant according.
No, that
yes.
has to be.
Yes, yes, yes.
That has to be. After the jail warrant only, the arrest part will come that he is going to prefer and so and so. Jail warrant has to be issued. That is no issue, I think.
There will be another separate seat of order.
Yes.
Hmm. Generally, it happens that after the pronouncement of the judgment, it's supposed to be later on. Later on, they may file a petition and on the basis of which there may be an order for previous bail. That's they are submitted that he is under previous bail will come. And accordingly prayed to allow him to remain on previous bail till disposal of the connected appeal. Till disposal of the connected appeal and also pray for disposal of the connected appeal, suspending the sentence passed by the judgment and interim judgment and order dated so and so by learned additional so and so. Considering next part, considering the submission made by learned counsel for both the parties, both sides, and also considering the period of the term of sentences and the conduct of the accused petitioner, appellant, the prayer is allowed. The accused petitioner, accused appellant is hereby allowed to remain on previous bail till disposal of the connected appeal by suspending the sentence imposed on him by judgment and order dated so and so, but by learned edition so and so. With the observation, I say it's good.
Two cases has been examined. Victim also the complainant lordship. I have analyzed this. Considering the length of detention and so far the evidence induced by the victim and the complainant lordship, and not bail the petitioner may be considered lordship. 200 days behind the bars.
Yes.
My lord, I have perused my lord scanned copy of the trial court record, my lord. So here, my lord, the evidence of PW 1 and 2, it is not available in the scanned copy record.
Not available.
Not available.
Huh? What?
This certificate lordship I have given. I don't know why this is. I have the original copy of the certificate. Page 23. Lordship.
Page 23 is certified.
I have given all certificate copy. Only once 164 statement that was supplied. I have added this. Page 23.
164 is also not available.
164, my lord, it is available, my lord. Now, my lord, when the trial is begun, my lord, because it is, my lord, 164 statement is not, my lord, it is not necessary, my lord, because the PW1 C is implicated, my lord.
No.
As he has annexed, my lord. Yeah, page number 23, Rosin may kindly peruse, my lord. Because her age is to be looked into, my lord. She says it about 16 years, my lord. Her consent is not valid. Page number 22, 24, my lord, first two line, my lord.
evidence is in favor of the accused. So she stated that she voluntarily along with the petitioner.
Yes. What is your submission?
Yes, Your Lordship. I would speak in consonance with what our learned PP has said. The age of consent is set at 18 years. So this girl being 15 years, 5 months, her consent even for any sexual activity will not count. Also, Your Honor, may kindly take into consideration the age gap between the accused and the victim. It's of 9 years. And also, if we speak of the 164 deposition, right, at that moment, she may have been under the influence because that incident had just occurred. And so she may have been under the influence. But right now, Your Lordship, I feel that at least the mother should also be examined.
When mother is examined?
Father was the informant, father examined. Father examined, Lordship, page 26.
He says that father is the informant.
Father was the informant.
Yes, Your Honor. Yes, Your Lordship. The reason why I'm saying is because since she has already made a mention of a mother, so I feel that she is also one of the vital witnesses, and at least
Whether she is listed as a witness there?
yes, Your Lordship. In the charge sheet.
Charge sheet, Lordship, page 17, Your Lordship will see.
Number 3 and page 17.
Once the Lordship victim examined, what will more come?
So, Your Lordship, by virtue of that, in the first paragraph itself, in her examination in chief, she has directly implicated the accused.
What is there?
Please read
Lordship,
paragraph, the first paragraph
Paragraph.
of the PW1.
Yes.
Sir, please, sir.
Why not page 23, Lordship?
Lordship, the first sentence, page 24.
It should continue from page 23, Lordship.
Yes. Page. So, Your Lordship, it's direct implication. So, Your Lordship, I feel that at this point of time, the accused should not be enlarged on bail because at least the mother should be examined because since there's a mention of the mother as well in her deposition. So, Your Lordship, that is my submission.
And the victim has examined and victim has stated in favor of the accused, Lordship.
Victim, apart from victim, suppose if you go by the evidence of PW, the informant,
yes,
who is examined as PW1, 2 also.
Well, at one
In his cross also, he specifically stated that it was not rape or whatever.
Yes.
And she eloped with the accused most probably for the second time. Earlier she was there and then again she went. Otherwise, we may feel that till the examination of victim or the informant, there may be a chances of so and so, hampering or tempering. But here in this case, it is seen that there may not be. May not be any chance of hampering or tempering. Just strictly speaking. Otherwise, what is this? Suppose if a minor girl is there and there, the chances of tampering the evidence of minor girl will be there or the informant. But here the case doesn't seem so because he is in custody since
200 days.
200 days. Today.
My lord.
Since when he is in custody?
Since from Lordship 22/5/2024.
22/5.
2024.
Okay, we'll try past it.
Okay, in this case, my lord, I'd like to, my lord, refer one judgment, my lord. That of Rajasthan versus, my lord. And another, my lord, victim name has not been mentioned, my lord. Also, may kindly fill the paragraph number 15 and 16.
15 and 16. Two types of things are by the apex code.
Yeah.
The
Regarding
limitation of-
delay, my lord, I have nothing to submit because the honorable apex has already hold, my lord. If there is, my lord, inordinate delay in trial or my lord, the prolonged incarceration, my lord, then my lord, it may be a case of bail, my lord. So in this case, my lord, what I have lordship has already, my lord, found, my lord, that two accused persons have already been arrested, sorry, my lord, examined, my lord. Now lordship, if lordship grants bail considering their deposition, my lord, for evidence, my lord. As per the my lord, order of this honorable apex court, my lord, it will hamper the, my lord, it may go against the, my lord, trial of the accused person, my lord. Or the
Now, if you go by this, definitely, but if you go by this, suppose the victim is the only witness, suppose, or thing, who can tell everything in against this, and there are other witnesses who are maybe the supporting witnesses, even the parents or even the others. So there are some cases where the heinous crime is there. It is also considered to be a heinous crime. I won't say that because a minor girl is minor, but she eloped with the boy again for two times, even after the recovery of earlier. These are the situation, in fact. Otherwise, obviously, in serious cases wherein the girl is of 12 years, 13 years, and even if the recording of the victim, that may not be a case for release of bail, because hampering of the other witnesses probability may be there. But here the situation is a bit different. It seems to be a bit different.
For the other witness, my lord, if he is, my lord, threaten the other witnesses, my lord, although they may not be, my lord, important, my lord, but they may come, my lord, gone hostile, my lord. Other witnesses.
That's what I'm saying. If you go by the evidence of these two witnesses itself, these two witnesses have you gone through, then what will come?
My humble submission, my lord, she is implicated because my lord, she has said that she has been raped, my lord. That is the word, specific word she has mentioned. It is not mentioned that, my lord,
That is the word if she says, suppose, that will remain because it is already in the evidence. And other witnesses, if it is supposed threatened also, whatever, they just will be obviously a hearsay evidences because she is the only victim. Only victim, and she is the person who know everything up to still. And that is the reason I just want to say.
My submission may be recorded. my lord.
Definitely. Heard Mr. M. Khan, the learned counsel for the petition. Also heard Mr. R.J. Borva, the learned additional PP appearing on behalf of state respondent. And Ms. M.K. Brown, the amicus curiae, learned amicus curiae appointed for the appear on behalf of the respondent number 2. Respondent number 2 is a informant?
Informant.
That's informant. Stop. This is an application by Hinlikidio, so and so, so and so. Scan copy of the case diary has already been received. Where is the same hard code side? Next para, it is submitted by Mr. Khan, the learned counsel for the petitioner. The present accused petitioner is innocent and innocent and innocent, and he has not committed any such offense as alleged against him. However, it is a admitted fact that the victim and the accused had love relationship, and out of which he eloped with him out of her own consent and will. Further, he submitted that out of 10 witnesses, 2 witnesses have already been examined. That is the victim as a PW1 and the informant as PW2, who are considered to be the vital witnesses of the prosecution. Further, he also submitted that the accused is behind the bar since last 22/5/2024, and hence, considering his length of detention, also he may be released on bail. Further, he submitted that the 2 vital witnesses of the prosecution have already been examined, and considering the evidence on record, it also can be deemed that there cannot be any probability of hampering or tampering of the other witnesses who are yet to be examined by the prosecution. He, being a permanent resident of his address locality, will appear regularly before the court as and when the date is fixed. Next part. Mr. Borva, the learned edition PP submitted in this regard. that DPW1, the victim of this case, also directly implicated the accused petitioner, and even if she gave her consent, it cannot be considered as a consent, as she is not attained her majority. More so, he submitted that even if the two witnesses are already been examined, the probability of tampering with the evidence of other witnesses cannot be denied at this stage. In that context, he also relied on a decision of the Honorable Apex Court, reported by 2024 0 Supreme SC 1106, and basically relied on para 15 and 16 of the state judgment, wherein it has been held that even after examination of the victim, there may be impact on the pending trial of the case, and probability of tampering the witnesses cannot be denied. Next paragraph. MS Brown, the learned amicus curiae, appearing for the respondent number 2, submitted that the victim implicated the accused petitioner, and from her evidence, it is seen that she was raped by the accused, who is 9 years elder to her. She further submitted that the victim was around 15 years at the time of the relevant incident, and hence her consent cannot be considered as a legal consent. Accordingly, she raised objection and submitted that it is not a fit case to allow the accused petitioner to go on bail at this stage. Next paragraph, considering the submission made by learned counsel for both sides, I have also produced the scanned copy of the LCL, the statement of the victim recorded under section 164 CRPC, vis-a-vis the evidence of PW1, the victim, and the PW2, the informant of this case. Considering the evidence on record and other aspects of the case, I find that rest of the case, I find that further custodial detention may not be required for the ends of justice, and it is also seen that the prosecution has already examined the two vital witnesses of the prosecution, and considering all these aspects of the case, this court is of opinion that this is a fit case wherein the bail can be granted to the accused petitioner. So and so forth. Where it is pending? Special Judge to the satisfaction of Special Judge Bongaitan. Okay, you are granted bail. So your information was correct. His client has given his. Anyway, we have received the case diary then. Oh. Yes, Biswas, what is the case?
Well, the case is that 16 grams bitumen was found in front of the dhaba of one Mr. Nath. Then, my lord, police Shomur registered a case and seized those bitumen and arrested one person, my lord. But your lordship kindly peruse the order, my lord, page 18. What was the finding of the learned court below? That is 510. May I take you, lordship? 510. In pursuance of the order dated 3/10/24, the IO SI R. Marak is present with the case diary. His presence was sought to hear him on the bail application number such and such. In response to my query, in the order dated 3/10/24, the IO has submitted that he is yet to find any clue regarding the ownership of the seized bitumen. As regards one Tapajul Hawk, that is, the IO has submitted that though his name was disclosed by some accused Juvenile Abedin, his whereabouts is unknown and his mobile number is also switched off. The IO has thus submitted that investigation is yet to be over. On the bail application, the IO has not objected to the same and requested to saddle the accused with necessary conditions so that he cooperates in the investigation. So that Juvenile Abedin was granted bail. Then, my lord, I also filed an application before the session judge for pre-arrest bail. And my lord, I am passing over the copy. I filed one additional affidavit also to that extent. Dear learned session judge.
Additional affidavit?
Yes, I have filed, madam.
Answer again.
It has not come, madam. I am giving the copy, madam. Kindly, your lordship can peruse the order, madam. Lordship can peruse the order. Order is page 23, madam. Kindly peruse.
It is not even filed.
I filed. Filed, but it is not
Have you
come.
received? Then?
It is submitted in the office, madam. Additional affidavit. I have made
Then?
that I have brought it just to bring your notice that what is the finding of additional session judge. There also he says that there is no material against him. However, at this stage, bail is rejected. The case judge reveals that the investigation is at early stage, and at this stage, investigation, the prayer for anticipated bail could not be considered. This is the finding.
If you want this, then because
And now I don't know what is in the CD, madam.
Those stolen bitumen, drums of 19 numbers of stolen bitumen has been recovered from one person named Juvenile Abedin.
From him it was recovered.
Juvenile Abedin, another person.
Yes.
Along he's in connivance with the present petitioner, they have tried to stolen those articles from a tanker option. Otherwise, so far as independent witnesses statement is concerned, they have implicated as a present petitioner also.
But IO said that there is no material against this Juvenile Abedin. Your lordship has just seen it. And till today, there is no claimant has come forward. Where from it has come? It was found in the nearby dhaba of one Nath at Thelamara.
There is a statement of one Julan Nath. So I'm reading his statement. I am a businessman and I'm doing a I'm a businessman and running a business. From last 2 months, the person Juvenile Abedin, along with Tapajul Hawk, the present petitioner, has been stealing bitumen. They, along with truck driver, take out bitumen from the tanker and stored the bitumen besides my dhaba. Yesterday, on 23/09/2024, the police from so-and-so PS seized a raid over and apprehended Juvenile Abedin and seized a stolen bitumen. And this person has fled.
So Juvenile Abedin has been arrested and enlarged on bail on the found that there is no material against him. In the finding of the landed magistrate. And landed session court also said that there is till now no material against me.
She is submitting from the CD only.
Yes.
Submitting the order of the honorable.
You have filed order of no, it's not that she is submitting from herself, it is from
Yes,
the CD
yes.
only.
I admit that.
And the co-accused also implicated the present petitioner also.
Mere acquisition will not do. It must be substantiated with something material. Mere acquisition will not do. Your lordship knows what is the fate of the ultimate
investigation.
ultimate. Yes, investigation is being doing on what is the ultimate fate of the acquisition in a trial. It is not a substantive evidence.
Otherwise, Lordship, the stolen bitumen has been seized, 19 drums, Lordship, and the seizure list is there. And sample of those stolen bitumen has been sent for FSL, Lordship, whether it is a bitumen or other substance, Lordship. That much is there.
And I have also made a local person. I was not here. I was in Arunachal Pradesh. Madam. I have come when police visited my house. My wife has sent a message. And now this is
Now
the
he,
position.
the arrested person, who is the general habitant from whom it was recovered. Is there any material? Is not, I mean, material is not, I mean, there's no implication against that general habitant.
Pardon, Lordship?
No, general habitant is already granted with bail as he has
Yes, yes. I have
in
annexed the
consideration
document.
that there's no such material.
Yes.
But as per you, this CD, the materials are there against journal also.
I can give also. Lordship. I'm reading the statement of journal of it in Lordship. The above mentioned information about me is true, along with Tapajul Hawk of so-and-so village, near a tire shop, one Brozennath Thaba, under so-and-so PS, the driver of bitumen tanker, and to come to have the English language is something. I, along with Tapajul and the present petitioner, used to take out the bitumen from the tanker after speaking on or communicating verbally with the tanker driver. We both used to take out bitumen from tanker and fill in a drum. After filling the drums with bitumen are kept on backside of her tire shop. Yesterday on so-and-so, while I was storing bitumen in drums and keeping the drums on backside of the tire shop, the police apprehended me and took to the police station. So this is his statement. And one independent statement. He is a businessman. He is also implicated that these two persons in connivance with each other, they have made alleged theft, Lordship. That much is there in the city. Lordship may parents.
So what, as per you, is it a case of and prayer has been?
Otherwise, those stolen bitumens has been recovered. Lordship.
There is no claimant till today. Whose bitumen will belong?
No, it was doing in connivance with the truck driver. I mean, yes. Tanker driver.
From the
That is there.
tanker. That is there.
Who will take
It was, no, it was coming for the supply tanker was there now from the drums bitumen.
Yes.
From that tanker, it was stolen and stored, and they used to do
ownership
so.
is not-
Ownership, how will come ownership? Who will claim? Nobody was there.
Nobody's knowing also. Who has
Nobody is not known to anyone, in fact.
Because they used to.
Because
they
they used
do it
to
on a
steal.
regular basis, Lordship.
I say that the case is charged. Then case is, suppose the case is charged against these two persons. Who will come and prove that it is their stolen property? How it will be proved?
That is a fact. That is.
Your lordship has
That is
vast
the stage of
experience
trial,
in the
Lordship.
judiciary.
It will be under case of trial, in fact. Anyway.
I am a local man. I assure you, lordship, that we will cooperate. Where IO has come to settle with the matter with condition that he may cooperate.
No, settle with the matter, in fact, for the other co-accused.
Yes. That is
not for him.
But on the same footing, my lord. He was inside, I am outside. That is the.
You are outside now.
Yeah, we are outside now. That is the only thing to be considered.
He was found to be at large during the time of investigation.
That is the least.
That is
Always
there in the city.
when police don't find anybody, he's on that.
So while he was found to be switched off, he was not at home.
I heard this was counsel for the petition. And also heard MSSH for additional PP appearing on behalf of state respondent. This is an application on section so-and-so in connection with so-and-so. Case diary received, perused received, and heard this right. This is submitted by Mr. Biswal, Juvenile counsel for the petitioner, that the present accused petitioner is no way connected in the alleged offense. And more so, the person from whom the bitumen was alleged to have been seized is already enlarged on bail by the learned trial court below. As there are found no such incriminating materials against him, and there is no clue regarding the ownership of the seized bitumen. POSCO. He further submitted that on the basis of there may be materials, the IO is searching for the present petitioner only on the basis of the statement made by the co-accused. But there is that's all. This statement made by the co-accused who has already been arrested, was arrested in connection with this case. If Mr. Biswas further submitted that till date, there is no claim regarding the ownership of the bitumen, which is alleged to have been stolen by in the FIR, so motor laws by so motor laws against so motor laws by the police officer. Mr. Biswas further submitted that he is still ready and willing to cooperate the IO in further investigation of this case if he is granted the privilege of pre-arrest bail. He being the local resident of the address locality, there is no chance of absconding, even if the accused is granted with the pre-arrest bail. Next part, MS SH Bora, the learned additional PP submitted in this regard, that there's a sufficient incriminating materials against the present accused petitioner. And from the statement of the co-accused and the independent witnesses also, it is seen that the present petitioner, along with the other co-accused, used to steal the bitumen and bitumen in the backside of the tire shop, and which were already seized by police in connection with this case. She further submitted that the bitumen has already been seized. The sample from the seized bitumen has already been sent for FSL, and the FSL and the report is still awaited. Result of the case diary, it is said that till that there is no claim for ownership of the bitumen, but from the materials available in the case diary, it is seen that there are some incriminating material against the present accused appellant also, which is brought against him by the co-accused as well as one independent witness. However, considering the submission made by the learned counsel for the petitioner, I find that this court is of opinion that interim pre-arrest bail can be granted to the present accused petitioner so that he can appear before the IO and can cooperate in the investigation of this case. He will be under interim protection.
Yes.
List accordingly, and this time Bihu pisar ki date ase after Bihu? After Bihu? 19 to 19. Ki date ase? 22nd of January. There will be some condition about by all conditions.
Develop.
CDB.
Yeah, please, my lord.
12.
Yes, my lord. I can tell. Yes, my lord. I'm challenging, my lord, the charge sheet, my lord. Charge sheet and my lord, impugn order dated, my lord, 3/6/2023, my lord. That order, order dated 3/6/23, my lord. This order may be, my lord, page my lord 34, my lord. Page 34, annexus 6, my lord.
Page 34 is not the order, it is charge frame.
Yes, search frame. Order, my lord.
Where is the order?
Yes, order, my lord,
32, my lord. Order number 32, my lord. 32, my lord. This, my lord, order may be the framing of the charge, my lord. The 5 head, my lord. The next page, my lord. Page 32, 34, my lord. The first charge, my lord. May I read, my lord? First is 31/10/2019 and about so and so time near Beltola College, Kamrup Metro, wrongfully confined and victim girl while she was going home from her college and thereby committed offense punishable under section 341 of Indian Penal Code and with my permissions. Second, my lord, second charge, my lord. So and so dated so and so time near Beltola College, Kamrup uttered words which were obscene in nature to the victim girl in public place while she was going home from her college and thereby committed offense punishable under section 294 Indian Penal Code within my cognizance. Third charge, my lord. So and so dated so and so time near Beltola College, Kamrup used the criminal force the victim girl intending the outrage of her modesty of the victim girl while she was going home from her college. Thereby committed next page, my lord. Offense punishable under section 354 IPC with my cognizance. The fourth charge, my lord. So and so dated so and so time near Beltola College, Kamrup, you committed the sexual assault upon the victim girl and you removed the sunni of the victim girl and touched the private part of the victim girl age about so and so while the victim girl was going home from her college. They have committed offense punishable under section 8 of the POSCO Act with my cognizance. And my lord, that I'm challenging, my lord, fifth charge, my lord. Fifth charge, specific mention, my lord, that you committed penetrative sexual assault upon by victim girl by coming from room of the victim girl is absent her mother, hereby committed offense punishable under section 4, the POSCO Act with my cognizance, my lord. Here in this charge, my lord, framing of the charge, this section 4, my lord, the charge, my lord, CRPC, my lord, 2, subsection B, my lord. This is defined of the charge, my lord. There are no specific defined, my lord. The charge. Charge means include any head of the charge when charge contains more head than one. Then let's see, my lord. Page 2112 217 CRPC 212. May I read, my lord? Yes, my lord. The contents of the charge 211 and 212. The particular is a time, place, and person, my lord. Specific mention, my lord. 212, the CRPC. The charge shall contain just particular as to time and place of the alleged offense, and the person, if against whom or thing, if any, in respect of which it was committed as a reasonable sufficient to give the accused notice matter with the which this is searched. Here in this case, my lord, the 5 head of charge, my lord, there is no specific time or day, my lord. Now, my lord, the CRPC, the schedule of second schedule, my lord, the provision, my lord, section 30. Framing of charge, my lord. From number 32, my lord. From number 32, my lord. This CRPC, the second schedule, my lord. This from number 32, the charge with on one head, my lord. Specific, my lord, name, office, magistrate, so and so, charge you, so and so, specific mention, date and time, and place, my lord. But my lord, the framing of charge, the 5 head of charge, there the learned trial code, there is no any specific date, time, and mentioning, my lord. And now, my lord, the fact of the case, my lord.
No, it's okay. You have challenge the charge.
Yes, my lord.
Okay, then what?
Section 4, my lord. This is serious and heinous, my lord. The imprisonment for life, my lord. Fact of the case, my lord.
FIR, my lord, page 15, my lord. The vernacular FIR, may I read, my lord? Page 15. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই বেলতলা কলেজৰ একাদশ শ্ৰেণীৰ ছাত্ৰী হওঁ মোৰ এবছৰৰ চিনাকি বন্ধু ৰাজেশ তুমুং প্ৰেজেন্ট পিটিশনাৰ মাই লৰ্ড দে ৰাজেশ তুমুং নামৰ ল'ৰাজনে মোক প্ৰায় প্ৰেমৰ প্ৰস্তাৱ দি অসুবিধা দি আহিছিল মই বাৰে বাৰে নাকচ কৰাৰ বাবে যোৱা এমাহমান আগতে মোৰ লগত থকা নিজ ঘৰত আহি মোক মাৰপিট কৰিছিল যদিও মই ঘৰৰ পৰিয়ালৰ ঘটনাৰ সম্পৰ্কে অৱগত কৰা নাছিলো কিন্তু আকৌ যোৱাকালি মই কলেজৰ পৰা ঘৰলৈ গৈ থকা অৱস্থাত দিনৰ 2:30 মান বজাত বেলতলা কলেজৰ সমীপৰ পৰা ল'ৰাজনে লগ ধৰি মোক চলিত ধৰি মাৰপিট কৰাৰ লগতে মোৰ গলত থকা চুৰ্ণীখন টানি লৈ মোৰ 6 ইঞ্চৰ প্ৰাইভেট পাৰ্টত স্পৰ্শ কৰি মোৰ শাৰীৰিক অপদস্থ কৰে দিছ ইজ দি FIR ইউনিট as FIR registered under section 341 325 354 354 AIPC ready section 8 of the POSCO Act. Thereafter, my lord, the investigation officer charge sheet submitted, my lord. The charge sheet, my lord, this will be considered.
They will file their objection and all.
It is memo of appeal, my lord, he has not enclosed the, my lord, judgment, my lord.
Oh.
Let him, my lord, annex the judgment, my lord.
Judgment not annex? Why? Page 10.
What are they, my lord?
Page 10. My lord, copy will be furnished, my lord, no problem. Effective signature.
Here also, along with the appeal memo, it's not furnished, but judgment is available here.
No, my lord, the IO will be disposed of, my lord. Then, my lord, ultimately we have to go by the appeal only, my lord.
Yes, obviously.
Then, my lord, he should, my lord, annex the copy of the judgment.
Here also, appeal memo is not accompanied with any the judgment. But yes, obviously, judgment is there in the first
Judgment is there in the IA, my lord. But it is mandatory, my lord.
Not in the appeal also. My lord, what happened?
It will be appeal na IA. It
May I submit, my lord?
You're
At the time of filing, my lord, at the time of filing, what happened? Inadvertently, my lord, judgment was not annexed to the petition. Thereafter, we removed the defect, my lord. And in the judge's copy, my lord, copy is there. But in learned friend's copy, my lord, that is not supplied inadvertently. We'll supply, my lord.
Okay.
We'll supply. Within the day, my lord, immediately.
One I is there, I criminal 1210. It to issue notice kori dibo. Issue notice. How many appellants are there?
6.
Appellants?
12, my lord.
12 appellants.
12.
It's a case of?
Case of
302.
302, my lord.
302.
302.
আৰু বাকি ৰেসপন্ডেণ্টক নোটিস কৰাই দিব ইন আই ইছ্যু নোটিস কৰি দিব ইন আই এন এপিল লিখক হাৰ্ড মিষ্টাৰ M.A. so and so this is an appeal under section 415 so and so লিখিব appeal admit কৰি দিব call for DLC and also issue notice কৰি দিব to the respondents to register DD and your process. Post-op. However, it is submitted by Mr. Borwa, the learned additional PP, that the copy of the judgment is not furnished along with the appeal memo. Post-op, Mr. Sheikh accordingly submitted during the course of the day, the copy of the judgment will be furnished to the learned course also. List accordingly. Right, we are called for the LCR corridor appeal. We appeal admitted and we are issuing notice.
But that sentence will not be written.
No, sorry.
Oblige your worship.
31 state is not there.
State
State
is,
is not a party.
state is a party.
Huh?
State is a party.
State is a party.
Lordship, the brief fact of this case is that, that I am the fair price shop owner, and the complainant, who is the private respondent here, is the ration card holder. And the allegation is that I did not allow her to lift the PDS articles which are allotted in her name. And when she had visited my shop, I have misbehaved with her, and I have embezzled the products which are allotted in the name of the complainant. These are the brief facts. And accordingly, she has filed a CR case with a request to register the FIR against me under section 407, 420, 506, 503, and 294. Thereafter, what happened? The learned court below directed the OC of the Arkanagar police station to register a FIR against me. And this complaint, Lordship, will find in the page number 11. And I am trying to quash the FIR as well as the charge sheet, as well as the proceedings of the PRC case on the ground that no criminal case is made out against me. And the ingredients to constitute the offense under the sections are also absent. Absent because the nature of complaint and the nature of the dispute in between me and the complainant is a civil nature of dispute. And for that, there is a redressal forum.
Non-distribution of PDF rights is a civil nature. Can it be?
No, I'll come. There is a grievance redressal forum which is constituted as per the NFSA Act. If any person is aggrieved, they can approach to the grievance redressal forum. And second thing is that it is civil nature because there is a dispute that some of the beneficiary whose names were included in the ration card which is headed by the complainant Priti Rani Pal, some of the beneficiary themselves raised complaint that fraudulently she has included their name in the ration card. And Lordship, second thing is that the fingerprint scanning is important, and it is the common system. The head of the family, in the name of whose the finger card is issued, her fingerprint has to be scanned. But in the case, which is the head of the family and who is the complainant here, her fingerprint has not been scanned. And he never visited the shop to collect the articles. And this is also, I have informed the supply inspector that she is not coming to my shop to collect the PDS article. Her fingerprint has not been expired, and some of the beneficiary also raised complaint. Lordship, I'll explain all these things. The complaint petition first, I may be allowed to read out, which is in the page number 11. Yes, non-distribution of the PDS articles and emblazing the PDS articles is a criminal offense. But the nature of offense in my case is different. It is not the embracing the articles, it is the complaint raised by some of the beneficiary and some of the officials. Okay, I have the permission to read this complaint.
Just you read whole complaint, no need. What is the important any paragraph and all?
This is only one page.
Oh.
Because I think, as my understanding, the entire page is important. If I read someone, then the accused person is a very weak and dishonest person.
Page number?
Page number 11. It is a translated copy.
Yes, page number 11.
I am a complainant living below poverty line. My mother, Hemlata Pal, died on 10/5/2019. She was a beneficiary of old NFSA card number so and so. There were altogether 11 members of our family, including my mother, brother, and others, were the beneficiary of the NFSA card. I am an unmarried lady. Therefore, I had presented an application to the authority of Civil Supply Department, Karimganj, to transfer the said NFSA card in my name. it is pertinent to be mentioned that along with the application, I had submitted all necessary documents after my mother's death. Whenever I went to get the PDS articles from the fair price shop, the accused person showing various excuse did not give the goods which were allotted for the beneficiary of my mother's card. During COVID pandemic, the accused person also did not give us the allotted food grains, rather she embezzled the same. Thereafter, I had lodged a complaint to the Food and Civil Supply Department. That part is important. Thereafter, I had lodged a complaint to the Food and Civil Supply Department. After receiving the complaint, concerned officer of the Food and Civil Supply Department Supply Office named Minal Hussain instructed me to remain present in the DC office on 15/7/2022 for hearing. Accordingly, I had attended the hearing, and after perusing the necessary documents, the concerned area officer ordered me to collect PDS articles from the accused person. Thereafter, I had collected my new card number. So earlier it was the old card, and now we are coming to the new card. That is why I'm telling that it is not a criminal offense, because there is a multiple dispute. Thereafter, I had collected my new card number from online number, and my new card number is so and so. Repeatedly, I had approached the accused person to obtain the PDS articles, but showing different excuse, the person refused and harassed me, and her other family member also insulted me. I had informed some mediators about the incident on 25/11/2023. Morning around 9 a.m., I went to the fair price shop of the accused person along with 1 and 2 number witnesses. Then the accused person badly scolded me and accused the accused person also another 2-3 person, and they pushed me out of the shop. In brief, these are the allegations. So, Lordship, and for that, at least in my understanding, the record will reveal that where is the criminal offense, and for that allegation, criminal law cannot be set in motion against me. What does say the Lordship? What is the criminal breach of offense? It is very categorically stated in the dishonest in the 406 misappropriation of property. Criminal breach of trust 405. The punishment is the 406, and whoever being in any manner entrusted with property or with any dominion over the property dishonestly misappropriates or converts to his own use that property, or dishonestly uses the disposes of that property in violation of the direction of law, prescribe the mood in which such trust to be discharged. So this is the criminal breach of trust. That is, if I use some property for my personal gain in violation of the direction of the law, only then the section, it can be said that I have committed the offense under this section. Now, Lordship, I'm just chart sheet now, what are detailed. Then the ration card details is there in the page number 31. As I have already submitted, there are some beneficiaries who has himself raised complaint. Page number 31. In the second column, Lordship will find the scheme name PHH31. The card number is there. And the fingerprint is showing that yet to be scanned you, the last modified date so and so. There is a fingerprint yet to be scanned. And the beneficiaries are Jitendra Pal, Shelly Rani Pal, Subroto Pal, Nipendra Pal, Vishwajit Pal, Prosenjit Pal, Orijit Pal, Sabita Pal, Priti Rani Pal is the head of the family. Lordship, this Shelly Rani Pal has raised in complaint. She is one of the beneficiary, as her name is recorded in the card. This Shelly Rani Pal raised complaint to the Food and Civil Supply Department that her name has been fraudulently included in the card, and the new card has been obtained by the complainant fraudulently. It is not me. It is complaint is raised by one of the beneficiary whose name has been included in the card. This complaint date 33, page number 33. Very so small complaint, your lordship, I may be allowed to read out. It is addressed to the Food and Civil Supply Department, Karimganj. Complaint against Sri Priti Rani Pal, NFSA cardholder. This Priti Rani Pal is the complainant in my case also. I have the honor to state that I, Sri Shelly Rani Pal, wife of late Jitendra Pal, village so and so, so and so. My NFSA card is so and so. In spite of my repeated complaint, separate NFSA card is issued to my sons Prasanjit Pal, Orijit Pal, Biswajit Pal, brother-in-law and brother of my husband, namely Subroto Pal and Nipandra Pal, and sister-in-law, sister of my husband is Priti Rani Pal, who is the head of the family in whose name card has been issued. I came to know from my agent that NFSA card is issued to them having card number so and so, which cannot be done as per the existing rules because the house number remain unchanged as per 2011 census. House number is one which recorded in my card. Surprisingly, two different NFSA card is issued against the same house number. New NSFA card issued in violation of the guidelines. Therefore, the concerned authority may conduct necessary inquiry and may take new card holder's name in my NFSA card. Thereafter, what happened, Lordship, and when one of the beneficiary filed the complaint to the Food and Civil Supply Department, then I wrote a letter addressing to the Food and Civil Supply Department, which is in the page number 35. The content of my letter is that in spite of the allotment, the complainant Shelly Rani Pal is not coming to my shop to collect the PDS articles. The subject itself referred the prayer for inform you that one ration card number so and so, he has not taken rice from my ration shop. I have the honor to state that I, Srimati Lovely Debroy, agent of the Gandhigram Samabay Samiti of Gandhinagar Mahila Samiti, I would like to inform you that my customer Sri Priti Rani Pal, daughter of late Jitendra Mohan Pal, is the above said cardholder, does not visit my fair price shop to take PDS rice. Even then, she does not communicate with me. Therefore, I am facing problem with their rice because rice pending in my shop and being rotten. So the question of stolen, theft, or embezzling the rice does not arise because already I had communicated to the authority that the cardholder is not coming to my shop to take the allotted rice which is allotted in her name. He is not coming only because there is a dispute in between the beneficiary. And because of that dispute, her fingerprint has not been scanned. And until or unless her fingerprint is scanned, the rice cannot be delivered to him. Accordingly, another aspect of the Lordship, the most important thing is that when she filed the CR case and the learned court below directed to register the FIR against me, hiding this material facts of the case, that the series of complaint after complaint, hiding these facts, she had filed the case, and without hearing me, the learned court below ordered the police to register a FIR against me. So no opportunity was given to me to defend myself in the court. Therefore, what happened, Lordship, this complainant had lodged a complaint to the State Vigilance Commission. And the State Vigilance Commission forwarded her complaint to the food inspector of the Food and Civil Supply Department. And the Food and Civil Supply Department requested twice her to attend the personal hearing to solve out the problem. She remained absent. And while she remained absent, she approached to the court and lodged a CR case. Accordingly, FIR is registered. These letters are here in the page number 37 and 39. This is important. It is issued by the Sub-Inspector, Food and Civil Supply Department, Karimganj. It is addressed to her, Priti Rani Pal, who is the complainant. Subject, personal hearing. Your petition to the Vigilance Commissioner Guwahati so-and-so with reference to the subject cited above and per direction given by IC Food Public Distribution and Consumer Affairs Karimganj, you are requested to be present for personal hearing on 26th of March 2024 at 1 AM at DC office Karimganj, Food and Public Distribution, Consumer Affairs branch without fail. She remained absent. Accordingly, second reminder was issued, which is in the page number 39. Your petition to the Vigilance Commission so and so, with reference to the subject cited above and per the direction given by IC Food Public Distribution and Consumer Affairs Karimganj, this is for you to first reminder to be present for personal hearing on 16th April 2024 at 1 PM at DC office Karimganj, Food and Civil Supply Distribution, Consumer Affairs branch without fail. Now, Lordship, when these are the development which took place before filing the CR case. Now, Lordship will examine whether this development has been reflected in the order passed by the learned court below or not. If it is not reflected, obviously, then the case has been filed hiding the material fact and without giving me an opportunity to prove that it is not at all a criminal offense, it is a civil dispute. The learned court below directed the police officer in charge of the Arkanagar police station to register a case against me. Accordingly, case is registered. This order is there in the page number 16. But if the CR is received on transfer for disposal, complainant Pritirani Pal is present. I have gone through the complaint petition. I have heard the complainant personally and also learned counsel for the complainant. From the material available in the complaint, I am of the opinion that the case is required to be investigated by the police officer who also peruse the accompanying affidavit. Accordingly, the case is forwarded to the OC Arkanagar PS with a direction to register a case and submit the FF as early as possible. Very short order which reflects that I have highlighted. Nothing is reflected in this order. It is also reflected that just after hearing the complainant and perusing the complaint, the court was satisfied, learned court below was satisfied that I have committed crime. No opportunity was given to me in CR case. Although it is in civil dispute, because there is a grievance redressal forum, she may oppose to the grievance redressal forum. And when she was invited to attend for the personal hearing, it was invited by the sub-inspector of the Food and Civil Supply Department. He is a civil officer, not a police officer. So the matter could be resolved there also. He did not visit my shop to collect the PDS articles which was allotted in her name because there is a dispute and a complaint raised by one of the beneficiaries which is belong to her family, and the complainant name is also recorded in the ration card. So, Lordship, these things clearly proves that the ingredients of the section 420, 406, and the 506 are absent because it is not at all a criminal dispute or criminal offense. It is a civil dispute, and for that, the criminal law cannot be set out against me. I have paid, Lordship, this FIR as well as the charge sheet may be set aside, and the proceedings also may be set aside. And after filing the charge sheet, the FIR can be set aside as it is the settled position of law already decided by the Honorable Supreme Court. Paragraph number 7 and 8 says that after filing the charge sheet, the FIR also can be set aside. That's all my submission here.
For number 4, today is our first appearance in this case, so we need to file a written objection.
Why you waited for such a long time?
Yes, my lord.
We now neither we can
Yes.
fix it for part heard nor why. He most probably around 45 minutes he argued the matter. And you're sitting there, I thought that you'll be arguing the matter. Very first beginning of the year, you could have submitted this one. Who is your senior and guest counsel? Yes, his presence may be required.
Lordship, on earlier occasion, I also made prayer to stay the proceedings, and at that time the record was not available. So today, Lordship may consider my interim prayer.
That stay is not required, my lord, it can be disposed of, my lord. It can be disposed of, my lord, let the, my lord, respondent number 2 appear, my lord, before you know.
It can be, if they take more time, then the stay will be required. And if the within a short
stay
period of
won't be
time, if
there.
they file their objection,
But I won't keep it as a part heard because it will again face will be problematic.
It's a substantive case. It's investigator, my lord, he is not agreed by the, my lord, forwarding the, my lord, complaint to the, for investigation, my lord. Now he is coming, my lord, after filing of the searches, when he issued, he received, my lord, summons.
there is no legal bar at any time.
I am not submitting the, my lord, there is a bar, my lord.
I am aggrieved because unnecessarily I am being harassed, and I'll have to appear the learned court below in every day, which will abuse the process of law because the dispute is a civil dispute. That is why I am paying for the stay.
At a request made by the request made by the learned counsel. We are on 31, na? 31. Your good name? LP Bora. The request made by the learned. No, heard Mr. F. Majumdar, the learned counsel for the petition, also heard Mr. R.J. Borwa, the learned additional PP appearing on behalf of state respondent. The matter is listed for admission hearing. However, Mr. L.P. Bora, the learned counsel appearing for the respondent, submitted that the engaged counsel, senior engaged counsel, Mr. J.M.A. Chaudhary, is not available today and accordingly paid for an adjournment. Considering the submission made by the so-and-so prayer allowed, let the matter be listed when it can be listed then.
Weeks.
After 2 weeks. If it is fixed for after 2 weeks, then it will come after vacation. List after 2 weeks.
Can I pray for a date, Lordship?
After vacation, any dates of
And the first-
10th of February. 10th of no, sorry, 10th of January.
January.
Obliged.
More than visible.
May it please the worship. Worship, the item may be adjourned for the day. The scenery is out of station.
Huh? Sceneries?
Out of station. Let the matter be listed after 2 weeks.
What's the problem? We have some urgency in the matter. Can it be on Friday, Lordship? Because the.
Not possible.
Or then on next Monday, Lordship. Because I have some, because considering my urgency, the Honorable Court was pleased to give me liberty to serve Dusty, Lordship. I have done that. The matter was last listed on 14th. So, it can be disposed of, Lordship, because it is a pen. It is not pending, Lordship. It is already been disposed. And I matter, Lordship. Small issue involved, Lordship. Can it be on Monday next, Lordship?
Indicated. 16 lots. Actually, maybe listed, it may not reach also. There are lots of matters have already been fixed, in fact.
Lordship, let me try my luck, Lordship.
Monday is 16th. 16th, how many matters can it be fixed? Already fixed matter, how many matters are? There are lots of fixed matter are there, I think. Can it be listed or if it is not?
On or 17 or 18 also, that will also do.
Best will be on 18th. The request made by the learned counsel for the respondent, list a matter on 18th.
I'm okay.
Item 49.
Criminal filed for questioning of the proceeding, my lord. The PRC case, number pending report is intimated first class robbery, my lord. The well, page number 9 is the FIR. The main ground is a civil dispute, my lord. Page number 9 is the FIR. (406) and 420, my lord. The evidence is taken. Page number 9. May I read, my lord? Small paragraph FIR, my lord. The due record I beg to state that on 4/2/19, I had paid ₹50,000 only to below mentioned accused person through bank RTGS to purchase his small car. But he did not deliver the car within stipulated period of time and also did not repay the amount. He used to abuse me and also threaten if I asked that. So this is the FIR, and my lord, while allowing the petitioner on bail in the very first day without the case diary, this honorable court also observed in page number 12, the last paragraph, that page number 12. Last line, my lord. The informant in his FIR has made a vague allegation that the accused petitioner, after taking 50,000 from him, has not delivered his vehicle, which he was supposed to sell to him. The informant has not mentioned the nature of agreement between the parties or the amount fixed. Nothing is there, my lord, for what amount the vehicle was, my lord. Agreement was made, how much he paid, what is to be left, and my lord, what is the description of the vehicle. So, my big allegation, and this is my lord, civil nature, my lord. If I did not deliver my car, this is a specific performance in a civil court may approach, my lord. And this is my submission, my lord, and in support of this, my lord, may my lord rely to the 3 judgments, 2 of the honorable effects court, my lord, and 1 of this court. There is nothing more to for submission, my lord. 406 whether the ingredients are there, because there is no entrustment. In earlier case, your lordship has, my lord, the submission was made regarding the 406 ingredients. So, my lord, in 2019-11 SCC of my judgment, my lord, Anand Kumar Mahato, my lord, 2 or 3 paragraph I will read, my lord, whether such type of, my lord, in this case, my lord, an amount of ₹1 crore was, my lord, in this case was paid by the land developer to the owner of the land. And my lord, that amount was not returned back.
Which paragraph?
My lord, may I paragraph number 24. 24. Fact is, my lord, that whether this 1 crore amount is an entrustment, my lord, and is an honorable apex court held not, my lord. Paragraph number 24, having given anxious consideration, we are of the view that assuming that there is a security deposit of ₹1 crore and that he has misappropriated, the dispute between the 2 parties can only be a civil dispute. Paragraph 25, my lord, any effort to settle civil dispute and claim which do not involve any criminal offense by applying pressure through criminal prosecution should be deprecated and discouraged.
The court noticed the growing trend of business circles to convert purely civil dispute into criminal cases. We find it strange that the complainant has not made any attempt for the recovery of the money of ₹1 crore except by filing the criminal complaint. This action appears to be mala fide and not sustainable. Then, my lord, paragraph number 27. We are of the opinion that the present case falls under first, third, fifth category of the paragraph 102 of the judgment of the Bojan Lal case. The High Court erred in dismissing the petition. The appellant filed under 482. This was a fit case for the High Court to exercise the inherent power under 482. Then, my lord, 28. In the case of Karnataka versus Munishwami and others, 1977 2 FCC, in the exercise of whole some power, the High Court is entitled to quash a proceeding if it comes to the conclusion that allowing the proceeding to continue would be an abuse the process of the court, or that the ends of justice require that the proceeding ought to be quashed. The saving of the High Court's inherent power, both in civil and criminal matters, is designed to achieve a salutary public purpose, which is that a court proceeding ought not to be permitted to degenerate into a weapon of harassment or persecution. In a criminal case, the veiled object behind a lame prosecution, the very nature of the material on which the structure of the prosecution rests, and the like would justify the High Court in quashing the proceeding in the interest of justice. The next judgment I will refer 2023 SCC manner, Sushil Sethi and another. Paragraph number 7.2, madam. Paragraph 7.2, in Vesa Holdings versus so it is observed and held that this was that every breach of contract would not give rise to an offense of cheating, and only in those cases breach of contract would amount to cheating where there was any deception played at the very inception. It is further observed and held that for the purpose of constituting an offense of cheating, the complainant is required to show that the accused had fraudulent or dishonest intention at the time of making promise or representation. It is further observed and held that even in a case where allegations are made in regard to failure on the part of the accused to keep his promise in the absence of a culpable intention at the time of making to keep his promise, the initial promise being absent, no offense under 420 IPC can be held to have been made out. It is further observed and held that the real test is whether the allegation of the complaint disclose a criminal offense of cheating or not. Then the next paragraph, 7.3, it is settled law by a criterion of decision that for establishing the offense of cheating, the complainant is required to show that the accused had fraudulent or dishonest intention at the time of making promise or representation from his making failure to keep promise subsequently. Such a culpable intention right at the beginning is at the time when the promise was made cannot be presumed. It is seen from the records that the exemption certificate contains necessary conditions which are required to be complied with after importation of the machine. Since the DCS could not, so this is the effect of that case now. Paragraph number 7.4. In BY use, it is observed and held that quote that one of the ingredients of cheating is the existence of fraudulent or dishonest intention of making initial promise. The same, my lord, ratio is repeated, my lord. Then I will, my lord, produce one GLT 2017 of 2945. So in this case, there is no ingredient of cheating in my case. Next, my lord, paragraph 11, 12, and 13, Kishore Das versus Pinky Das. Paragraph number 11 and 12. The above definition of cheating, 11, my lord, has two parts. While the first part relates to property, the second part need not necessarily relates to property. To hold a person guilty of cheating, it is necessary to show that he had fraudulent or dishonest intention at the time of making promise with an intention to retain the property. The essence of the offense is that there should be deception either by express words or implied by conduct which may be direct or indirect. The offense of cheating is punishable under 420 and the offense is committed when on the basis of the fraud or miscellaneous, the complainant is induced to part of the property or valuable security. Therefore, if the alleged victim is not induced to deliver any property or valuable security, the offense under section 420 cannot be said to have been committed. The concept of deception should be present from the very start of the transaction between the parties. On careful scrutiny of the allegation made in the complaint, petition and the initial deposition of the complainant, along with the documents annexed petition, it is apparent that there was no dishonest intention at the time of initial transaction made by the opposite party and her husband with the petitioner, as the proposal to be book a flat was made jointly by the opposite party and the husband, and as such, the dishonest transaction was there on the part of the petitioner, and even thereafter, at the instance of the husband, opposite party, when the petitioner returned an amount of 2 lakh out of rupees 9 lakh received by way of advance money for said purpose on obtaining acknowledgement receipt thereof. The factors emerged from the complaint and the documents annexed thereto. The dispute between the parties appears to be apparently civil in nature, being related to contractual obligations, and therefore no criminal liability can be fastened upon the petitioner under section 420 ITC. So, my lord, my humble submission is that there is no ingredient of cheating and my lord, the criminal breach of trust. So the proceeding, my lord, cannot go, my lord, that maybe my lord state or my lord, at this stage LCR is received. Your lordship may go to the LCR and dispose of the matter, my lord.
And we receive also.
Can copy I
Receipt. We have received it.
And my lord, some amount of the 50,000 the petitioner is already repaid, my lord, to the respondent. And there is negotiation going on that the amount, the remaining amount also he will repay, my lord. So there is no criminal.
I'm for the respondent number 2, Your Lordship.
406.
Charges submitted section under 417.
No, already some amount is repaid.
No, nothing paid. 50,000 received, Your Lordship. This is admitted fact, Your Lordship. My friend already admitted in his para 4 and 5, Your Lordship. It is number 4, Your Lordship, para 4, Your Lordship.
No, admitted is okay. Now he is submitting that some amount has already been paid. Is
As per instruction, nothing received, Your Lordship, but promised to pay the 50,000, but not paid till date.
That was to there in the FIR only.
No, after that, Your Lordship, the petitioner promised to pay the 50,000, but not paid till date, Your Lordship. After filing of the case also.
Okay,
And
we
also,
await submission.
my friend's petition, that's also admitted, Your Lordship. The para 5 is last para, Your Lordship. Moreover, the petitioner is ready to pay the remaining balance amount to the informant, Your Lordship. Money is received by petitioner. That's a admitted fact, Your Lordship. And section 417, Your Lordship, and 420 and 406, Your Lordship, fully established, Your Lordship.
So, my lord, in the board below, the petitioner also might initiate the matter. So, my lord, a date may be fixed, my lord, by the honorable court, and regarding the admission of the taking the amount, and the matter may be disposed of, my lord, to approach the court below where trial is going on, and to settle.
He is not admitting now. You are saying that you have
He is admitting that I am ready to pay.
No, that is your statement.
Yes.
Even after that statement, you are not paying. That is his submission.
Yes, my lord. The balance 40,000, my lord.
No, you are saying that balance amount. He is saying you not have paid anything.
It's 50,000 from, it is admitted. Money
It
was
is admitted. Now he is saying that some part has already been paid.
Some part means 10,000.
He has no instruction.
Claim that 10,000 paid, Your Lordship. But as per instruction, nothing paid, Your Lordship. But I have to take the instruction.
10,000 has already been paid.
I have this instruction, Your Lordship. No, there is no information supplied by the respondent number 2 that he is paid, he received something or not. I have to take the confirmation from the respondent number 2. And my friend also prayed for feast date, Your Lordship. Kindly date may kindly feast. I also take the full information. Whether receive or not. But till that, the respondent never informed that he has received anything, your lordship. A date may kindly fixed, your lordship.
Well, before the
On-
trial court date is fixed 11/2. So well, after 11/2, a date may be fixed, my lord.
In the last part of January, your lordship, on
Petitioners
20 or
may
21st
settle before the
January.
trial court also before this date, my lord. So may I pray for a date after 11/2.
After 11.
11/2, because before 11/2, they may, for the trial court, the matter may be settled by the court. So 11/2, a date may be fixed.
No, lordship. The last part of January, because there is no any discussion whether settle or not settle, your lordship. Any date, your lordship, but last part of January. मतलब आपने लोग voted था, ठीक है?
The petitioner is already ready to pay, my lord. So if some more time may be given to him, it will be better for both the parties.
Then my fair submission may kindly record it and fixed in date, your lordship.
State is also a formal party. Submitting before a length. You're submitting at a length, no, and before submission, you could have placed these things.
Yes, well, regarding.
Time
this
has
matter,
already gone, it's
Yeah.
already 4.
No ingredients of the.
No,
my lord,
that is,
the
I have already recorded,
cognizance
but the
is taken.
question is that now you are saying that some payment has already been made.
Yes.
You were interested to make part payment.
Yes. No
In
ingredients
this
is there.
stage, you could have made that submission. No question of reading these things, no? Had Mr. M.J. Kadir, the learned counsel for the petitioner. And also had you, Mr. A. Karim. A. Karim, the counsel for the respondent number 2. And Mr. R.J. Borwa, the learned additional PP appearing on behalf of state respondent. The case is fixed for admission hearing today, but at the time of hearing of the matter, Mr. Kadir, the learned counsel for the petitioner, submitted that the petitioner is still ready and willing to make the payment. And as per his instructions, some part payment has already been made. And accordingly, he needs, he's submitted that as date may be fixed. So that he can take proper instructions from the client. Further, from the petitioner. Further, he submitted that the case is fixed before the learned trial court below on 11/2/2025, and after 11, and he accordingly paid for a date after 11/2/2025, so that matter may be placed before the learned trial court below, and there is every probability of settlement of the matter before the learned trial court below. Next para, Mr. Karim submitted in this regard that he has no such instruction from his client in regards to payment of any, in regards to part payment of any money. However, he will take instructions and accordingly submitted that the matter may be listed at some other, maybe, no. He will take instructions and accordingly he also submitted that matter may be fixed after 11/2/2025. 11/2/2025 officer data sending.
21st of February.
21st of February.
I have some mistake in the mentioning the date. The date is not 28/2, not 11/2. 28/2 in the year book.
20.
28/2.
28/2. Then it will be too far. Huh?
Before that can be fixed, my lord.
Before that, you take instruction. If
Yes.
it is possible, then you may
Yes,
withdraw
before that,
also.
yes, before that can be
Isn't it?
fixed, but this date may be.
Yes, 220542. 28/02/2025. Date to fix আছিল. And এইটো prayer লিখক আৰু maybe fix তাৰপিছতে লিখক কৰিমৰটো লিখিব that submitted the prior to the next date of listing that may be fixed. এইখিনি কাটি দিওঁ
Interested, then he also paid here also before the registry, your lordship.
No, let the take instruction. What
Yes,
is the
yes.
mode of procedure? I mean, payment.
Yes.
I will not know. Because the main issue is the payment. Payment includes 50,000 rupee is the main subject matter of the case. If that is suppose he paid or he agreed to pay, then it's okay. Maybe cost, maybe disposed of, or maybe compromise, whatever. Otherwise, now I'm saying what 50,000 is the main subject matter, isn't it? Huh?
Main amount, Your Lordship, and in the 2019.
You want to claim interest also?
Lordship.
There's you cannot be claim interest here in this case. There's civil suit, under civil suit you can claim interest. আগতে দি দিয়ক তেতিয়া 4th of February 4-2 অলপ মিলাই দিব উল্টা পুল্টা কৰি দিলে ন শুনিব নালাগে আগতে ক'ব লাগে না ইমান দেৰি শুনাৰ পিছত আকৌ এইটো সাবমিশন দিয়া উচিত নহয় ন বিফৰ টাইমলে 4টা বাজিব নাই মা You are for the respondent.
Sole respondent.
Sole respondent. Petitioner is not here. None appears on call for the petitioner side. Hard MS, you are MS?
Then Japan.
Hard MS F. নামটো কি কৈছে লাই লৈ বসো নামটো কি কৈছে লৈ বসো so and so list accordingly after 2 weeks. We will list it after 2 weeks. Oh, Chaudhary was there. You were there, MS Chaudhary. Okay. Okay.
My lord, I'm the victim in this case, my lord, and my lord, outright this revision petition not maintainable on the ground of, my lord, the petition has been preferred by a stranger, my lord. Now, that issue has been kept open by virtue of the order passed by this honorable court on last occasion, 25/9/2024. Now, Lordship, state why I'm coming to the core issue, my lord, without wasting time. Lordship, page 2. Page 2. My lord, page 2 is the applicant. This is the Anjali Sharma. Petitioner is the name Anjali Sharma.
She is Anjali Sharma.
Yes. Page 2. Petitioner. Now, state Lordship, just take a turn to page 3, paragraph 2. Then the petitioner back to state the petitioner is the mother one Pratiksha Sharma, who has been implicated as the accused in the connection with the Chancery PS case number 98, 2020 under section 420, 406, 471 IPC short code passing off by this applicant. Therefore, on behalf of her daughter, mother coming by way of this revision petition, now, Lordship, kindly see page 8, affidavit. Page 8, affidavit, paragraph 1. That, page 8, paragraph 1. That I am the petitioner in the instant criminal petition, as such I am well acquainted with the facts and circumstances of the case. I am also otherwise competent to share and sign this affidavit. I have no authorization. Now, Lordship, state where I am coming to the FIR, my lord. What is the contention of the FIR? It's a very serious allegation that start from page 11. Page 11. It is to inform you that I used to be a citizen of India and a resident of the Guwahati till December 2005, since when I became a resident of Canada. Presently, I am a Canadian citizen by naturalization. My mother, Srimati Indu Devi, Indian passport number so has also been residing with me since 2018 in my residence at Oshawa, Ontario, Canada. I am working as a wealth and investment advisor to a private business concern in Canada. I am come from one of the oldest family of Guwahati with landed property inherited from my forefathers. And the name of my mother, Srimati Indu Devi, and myself have been recorded in Patada in several such plot of land after death of her husband and my father, late Chandranath Sharma. That I met Srimati Pratiksha Sharma, son of so on February 2012, and subsequently our child Kumar Diya Sharma was born 2015 to us. That at about same time, defense started erupting between my wife and myself, and we got separated on February 16, 2016. Since the date of separation, I have been through an ongoing separation divorce custody battle with my wife in the Superior Court of Justice of Ontario, Canada. And our last court appearance was on March 1, 2022 before the Honorable Justice so. That as part of the brief presented before the said court, Srimati Pratiksha Sharma through her counsel submitted a deed of agreement for sale plot of number so without any boundary, which was shown notarized in Guwahati on December 7, 2019 through one Srimati Anuma Bhagwati Vaishya, notary Guwahati, Assam. On careful scrutiny of the aforesaid document, I noticed that the signature of my mother and myself appearing in the deed was not our and bear no resemblance to our actual signature, which is evident on comparison to us. Authenticated signature is appear in our respective passport and bank documents beside the alleged deed was sold executed on date 7/12/2019, on which date both of us were in Canada and not in India, as we concluded our previous visit of our on November 2015, 2019, evident from the stamp endorsement made in the respective passport. Now, based on that, my lord, the FI was closed. And after this closing of FI, my lord, since there is a delay, therefore, my lord, we approached before the CGM for Honorable CGM Court for seeking the update status, my lord. Now, while seeking this updated status, my lord, a report was submitted where there is a serious allegation level against them, my lord. On May, I'm just putting before lordship. Now, my lord, taking into consideration of material fact statement of the parties concerned, finally, my lord, page 31, a observation was made by the IO, where it is stated, lordship, page 31, page number 3 otherwise. This is the latest report endorsed on 19/4/2024. Other this specimen signature of the complaint and the accused person have been taken in presence of GOs and
You have not filed your additional affidavit.
my lord, because my lord, appearance
No,
today
formal
we have
notice
made-
is not
let me
being
complete,
issued.
my lord. Maintainability is the issue that can be, my lord, otherwise, my lord, because
Then you don't go by these things.
my lord,
Otherwise,
then
he's not
lordship
copying.
statement, I am coming to the mate of the case. Maintainability issue, my lord. Lordship, two judgment I have placed straightway, whether the locus standi deserve or not. Lordship, first judgment, that is the reference of the in the High Court of Delhi at New Delhi, where, my lord, the true judgment of the Supreme Court has been referred in connection with the said issue. Same set of fact was lodged therein, my lord. Lordship will go to that Delhi, my lord, Amrinder Singh judgment, my lord. Yes, my lord. My lord, paragraph 7, my lord. Paragraph 7, my lord. There is a reference of, my lord, one case in Amit Ahuja versus Gen Prakash Bhandari 2010-3 RCR criminal. The observation is as follows. In the paragraph 9, the plain reading of the ratio of law laid down in the aforesaid case clearly goes to reveal that it is only the accused person against whom a criminal case has been registered or criminal complaint has been filed can file a petition under section 482 of the CRPC. In the High Court, for quashing the complaint, the summoning order and the subsequent proceeding, and no third person can fight a proxy war on his behalf under the garb of the public interest litigation. The aggrieved party who is affected by an order is required to seek redress of his grievance by questioning the legality, validity of the correctness of the same. It is another thing if the aggrieved party is suffering from some disability, unless such a party is minor, an innocent person, or is suffering from any other disability which is in law, is recognized sufficient to permit any other person next friend to move to the court on his behalf. On behalf of minor or innocent person or guardian or next friend, initiate proceedings so as to challenge the legality and validity of the orders passed against him to seek redress of the grievance as under law. Such a person having disability cannot be said to be competent to file a petition, except through a next friend of guardian. In the instant case, there is nothing on record that Amit Ahuja petition suffering from any disability recognized by the provision of law. He is an accused in the aforesaid complaint. It is he who is aggrieved against the complaint and the summoning order. It is he who can challenge the same on any ground which may be available to him under the provision of the law. If in criminal case, until and unless a person aggrieved suffers from some disability recognized by law, a stranger or some other person is allowed to fight the proxy war, then the very purpose of criminal justice system shall be defeated. In the event, the court would be assumed by the public interest litigants. In this view of the matter, the present petition under section 482 of the CRPC filed by the petitioner through his attorney is not maintained on this ground alone, the same is liable to be dismissed. Now, this is the ratio that has been laid down, that recognized by law can only be permitted to initiate minor criminal proceeding. Now, Lordship, another judgment is very important where two judgments of the Supreme Court has been referred. That is Shyam Sundar, my lord, that is Amit Ahuja versus Gyan Prakash Hambi, my lord. The relevant parts contained in paragraph 7 words. The same issue dealt with therein. But there is a reference of one Supreme Court judgment, 1991 380 497, paragraph 7 also. After giving my thoughtful consideration to the rival contention raised by the counsel for the parties, in my considered opinion, the petition is liable to dismiss being not maintainable for the reasons to be recorded hereunder. Admittedly, the aforesaid complaint was filed against the petitioner and his co-petitioner in the Court of India. There is no dispute about the fact that Amit Ahuja petitioner is residing in Dubai in Janata Dal versus H. Chaudhary and others, JT 1991 3 SC 498, it was held as under. Even if there are a million questions of law to be deeply gone into and examined in a criminal case registered against a specific accused person, it is for them and they alone to raise all such questions and challenge the proceeding initiated against them at the appropriate time before the proper forum, and not for third parties under the garb of public interest litigation. It was further held that the petitioner in that case had no locus standi to invoke the external jurisdictions of the High Court under Section 42 for quashing the FIR and all other proceedings arising therefrom on the plea of preventing the abuse of process of court. In the above mentioned case, the accused persons were allied and were capable of defending themselves and protecting their interests, and it was also not shown that the petitioner, Mr. H.S. Chaudhary, had any particular special interest in the accused person. Now, another reference is very important, madam. In Simarjit Singh versus Union of India, 1993 SC 280, Apex Court held as under. Ordinarily, the aggrieved party which is affected by an order has to right to seek redress by questioning the legality, validity, or correctness of the order. Unless such party is minor, an insane person or suffering from any such disability which is in law recognized as sufficient to permit any other person next pain or move the court on his behalf. It was also held that if a guardian or a next pain initiated proceeding for and on behalf of such a disabled aggrieved party, it is in the effect proceeding initiated by the party aggrieved and not by the total stranger, who has no direct personal stake in the outcome thereof. In the above mentioned case, the leader of the political party opposed the Supreme Court under Article 32 of the Constitution of India, challenging the conviction and sentence of the assassination of General Vaidya. The two convicts were alive but did not file any appeal against the conviction and sentence. The apex court held the petition in that case has locus, tending to invoke the jurisdiction under Article 13 of the Constitution. Now, same ratio has been again laid down, paragraph 9. The plain reading of the ratio of the law in the aforesaid cases clearly goes to reveal that it is only the accused person against whom a criminal case has been registered or a criminal complaint has been filed can file a petition under Section 42 CRPC in the High Court for quashing the complaint, the summoning order, and subsequent proceeding, and no third party can fight a proxy war on his behalf under the garb of the parliament. The same ratio that has been laid out there. Now, Lord, my humble submission is that, my Lord, who rested her? Number one, therefore, before this honorable court, once see that suppose suffering that this complaint case is not maintainable FIR. Second thing, my lord, can you see no ground has been assigned that why she is unable to approach before this honorable court. Third thing, lordship, can you see that it is a criminal proceeding. Any order may be passed, which may be otherwise adverse. Tomorrow that lady may differ, say that I do not authorize any persons to represent myself before the honorable court, like my mother even. Suppose any adversity will come, then will they take the burden? That point of time, the escape route is that I never authorize you. So therefore, under such circumstances, but the primary requirement is that it is a criminal jurisprudence which clearly demands that aggrieved persons, the doors are open, not third party. Yes, third party whom they are recognized by law who are disabled, like insane, minor, etc. Only that, my lord, window has been kept open for the persons who can come under the zone of third party, my lord. Other than, my lord, there are two Supreme Court judgments. If we go to the ratio, then it says no. If this proceeding will be allowed for a moment, my lord, then, my lord, then nobody will approach before the honorable court. Nobody come before the notary to sign that payment. Suppose one is from, my lord, like suppose Delhi, somebody is he, my lord, file a case on his behalf, my lord. Then if this practice would be continued, it indicates a good sign, my lord. It has to be stopped somewhere. Therefore, my lord, my humble submission is that, my lord, if we look into the perspective of the petition structure, a single whisper that has not been made that the mother has been authorized by her daughter. Number one. Number two, my lord, it is also nobody stated, my lord, that any authority that has been tendered to her, might be any power of attorney, my lord, or whatever, my lord, That has not been given. No, Lordship, this is one of the aspect that connected to the, my lord, aggrieved person, and that connected to the, my lord, accused person. But Lordship, simultaneously, another argument is also very important. Supreme Court said a third party, if victim can approach to the, my lord, to the court of law, my lord. Suppose a FIR has been lodged on behalf of someone else, my lord. That is permissible. My lord. Therefore, my lord, the distinction is that a victim can be represented by third party, but a accused cannot represented by the third party. Subject to only one window, that the persons who are recognized by law as disabled by law. There are two phases, my lord. One zone is reserved for victim person, where third party's entry is permissible. And another zone is that, my lord, so far the accused are concerned, my lord. There is a two citation I have given. There's 100 citation on this point, my lord, I have, my lord, gone through. That aggrieved person is only permissible. And zone is only reserved for that kind of categories person which has been referred to. My lord, my humble submission, my lord, on the score of maternity itself, which has been kept open by this honorable court on last occasion, which is the, my lord, the order date 25/9/2024, my lord. Lordship, just let them show a single instance, my lord, under what capacity, my lord, he presented this petition. That is my humble submission.
Lordship.
Yes.
First of all, what is submits? That is, obviously court held that accused who is aggrieved, he can only permissible for final crossing of any order. Here, we are not challenging any order. Here, we are challenging the FIR, crossing of FIR. For crossing of FIR, it can be filed anybody other than accused. If any abuse process is going on, if the FIR is filed with any ulterior motive or malafide intention, that is, for that there is no bar.
Whether in that case A, B, C, D, anyone can come.
No,
and
no, no,
propose.
no. Here, the mother of the accused is.
No, she may be mother, but she cannot be termed or considered to be an aggrieved.
Yes.
Is she?
Now, for filing crossing of FIR, if there is any abuse process is going on, or the FIR is filed with any malafide intention.
Obviously,
it
in
can
that
be
case,
stayed.
it is a case of washing.
It's a
We are
case of
not
washing.
disagreeing with you. In that case, it is a case of washing, but the question is that whether mother can file on behalf of her daughter, whether when she is not the aggrieved party. Because filing of the FIR, suppose what is the criminal case is set into the motion and all, she is not the aggrieved one.
Of course, but here the question is the daughter is a resident of Canada.
Obviously,
So
is there any authorization?
here, no formal power of attorney is.
Formal power of attorney is not there, nor authority is there.
No, he authorized, but.
Obviously, I can understand being a mother, most probably there may be a verbal thing also that you may file a petition for quashing and all. That can be understood. But for legally, if you go and her daughter, you cannot say her daughter is suppose a minor or insane or what, that is not there. Question of insanity or minority doesn't come. Now, that is the question he raised as to whether in that circumstances or situation, can it be, is it maintainable? Otherwise, very well, the daughter can come from Canada, obviously, in once or two occasions for filing or swearing an affidavit and can file. And other part, the advocate concerned may represent because you are authorized by the filing wakalatnama and all. That is also there.
Yes.
So by filing wakalatnama, the advocate can represent. It is not the case that she had to come every day, because it's not a case of recording evidence and all. That is there. Otherwise, if you have any authority with you, you can show us.
Can you fix it date?
My lord, law is very settled, my lord, sometimes. My lord, sometimes we try to just to get a support of citation, my lord, doesn't serve good purpose. It's a simple question, lord. It's a very pertinent question that ABCD anybody then come, my lord. Suppose somebody in Jammu Kashmir, okay, somebody, my friend is there, he will file a quashing. Lord, quashing petition is rare and rare cases, my lord. It is not a normal proceeding, my lord. Suppose any my lord, adversity order may even pass, my lord. Suppose a post may be imposed, taking that case. Suppose a warrant has been issued, my lord. Then we'll see my lord take the responsibility, my lord, or will that lady will take the responsibility, my lord. Question is that, my lord, suitability of the petition is the core issue, my lord. Anybody cannot oppose, my lord. This is a settled position. I have gone through so many citations. There is no such citation that a person can be represented by third party without having even any authority, my lord. Here is a case, my lord, kindly see, distinct. Even no power attorney also. My learned friend is saying that power. Where is the power attorney, my lord? Power attorney never, my lord.
No, he's not saying
I'm not saying that. I'm not saying
It's a
the power
criminal law,
attorney.
it's not a civil law, my lord.
I
In
will
CPC, my
produce the
lord,
authority.
certain representative can be, my lord, represent, my lord, suit, my lord. Not here, my lord.
I will produce the authority.
That's why in person, my lord, someone has been issued in person, my lord.
Moreover, what is submitted, he has not been yet noticed by the court. No notice is issued to him also. But though he appeared, he voluntarily appeared. My learned friend is. So
It's
I'm
good only. Why? You have to issue notice.
no notice is issued. Till that no notice is issued to him.
No notice?
No notice is issued.
Why? The issue was raised by him on the last occasion.
On last
regarding the
occasion.
maintenance.
So
I don't know, somehow he got the knowledge is there.
Sufficient, but let me one opportunity that I can produce any authority. Yeah. Only one date.
My lord, that, my lord, lordship can keep the part harmless because almost
maybe
everything is now open, my lord. If you want to place any citation, I don't know what citation will support sometimes, which is otherwise totally, my lord, well settled, my lord. Either he has to author himself, my lord. Law is very well settled, my lord.
Now, otherwise also this option is there. If you think that it is an abuser's process of the court or the process of law, but the question is that the person can come and file. Otherwise, if it is suppose it's not maintainable, also in that case, also your option will be there.
Yes,
Will be liberty by file such a petition by your the accused herself. Yes. Obviously, she stays in Canada. There may be some difficulty on her part. That is understood, but that will not be law. That is the question.
Just on 15 or 16.
Whatever, my lord, he wants to submit his citation, that can be submitted.
You want to keep it as part her?
He just want to show the citation.
Now, what do you want to say? Can they kept it at a CAV? You can file anything, or in that case, you may not get the chance to reply back. That's why.
Lordship may fix it for judgment, whatever lordship feel it good. If in between, if you want to submit any citation, that can be placed, my lord. That's all.
Okay, that will do.
Well, that's
Otherwise, I have kept it. Will be hard.
Unnecessary delay, my lord. Have no purpose, my lord.
No, he's not saying on that. Part heart is too different. I'm saying that if you find any authority in that regard, you can place it before us.
That's all, my lord. I will also.
Otherwise, we'll keep it as a CAV. For your convenience, that's a small matter. It can be disposed of today itself. But if you want anything to place within this week, this week if you file anything, then okay.
On 13.
No, we are not fixing any date. We are not fixing any date. He's just saying that you want any copy of this one. No. Not required.
Very small issue, qualification of that petition, my lord. My lord, lordship, if you allow this petition, anybody may come. Open the floodgate, my lord.
Then lordship, open
it is not a singular case.
Accused to come before this court.
They become precedent, my lord.
Then open it to the accused to come before herself, before this honorable court for quashing.
Open
it for the accused to come herself before this court. Then it's a criminal petition if it is dismissed or not maintainable. Then for the victim, for the accused, any option has to be left out or not.
Lordship, these are the lame excuses. Lordship fix it for judgment. In between, if I want to any authority, let him place before the court officer. That I think proper to my lord dispose this matter, my lord. Small issue, my lord. Unnecessary dragging, my lord, serve no good purpose. If some my lord legal points are there, yes, obviously my lord required. It is a small issue. You are disqualified simply.
This within this week, if you have anything, just place us
Yeah,
before us.
of course.
Otherwise, I'm keeping it as CB. Now, in fact, it is a very small issue. It can be heard and decided by instantly now. But if you want, said that if there is or any other authority, if you want,
Yes.
on rely on that, you can place it. But this week, within this week only.
Only.
Next week, it may be heard and decided.
Yes.
We are keeping it as a CAB on your request.
Okay.
Hard code, CAB code. But this within this week only, you find.
Of course.
What?
No time. Don't want to hear.
My lord, item 46, may I pray your lordship will take up tomorrow because having regard to the nature of the case, your lordship must.
Tomorrow, day after tomorrow, I cannot say because we don't have time, in fact.
Yes,
Every
well,
month, this
Thurs-
is almost.
On Thursday, my lord.
See, 58, 59 cases are almost every day is
On
fixing.
Thursday, my lord, 12,
Say, I can say. Item number,
46, my lord.
what kind of urgency you have?
My lord, in fact, your lordship will recollect, the matter relates to, my lord, the alteration of charge. So I, my lord, filed an application before the, my lord, trial court, saying that since the charge has been altered to grave offense, so kindly give me the opportunity to cross-examine, my lord, the witnesses. That was turned down.
Huh? No. 12. 46 to 12 for fixed period.
My lord, can I say, my lord, at 2 p.m., my lord, 2 p.m., because otherwise it may not reach, my lord.
I don't know.
2
Yes,
p.m.
at 12. 12.
Item number 44, my lord. This is relating to my lord, recalling of the warrant of arrest. My lord, in spite of the stay granted by the lordship.
Okay, now see, we don't have that. I mean, very frankly speaking, we don't have any days prior to. But if registry can manage, then definitely date came. So I'll list it for 1 week. List after 1 week. If it
No, my lord,
comes,
date may
then
be begun because
date we cannot fix. In fact, we don't
No,
have
my lord,
any.
Date is given in the law code act to appear, my lord.
I don't know what to do. What to do?
My lord,
Say what
that
to
is
do.
given on, my lord, days. Which date given?
Keep going on.
That is on, I think, when 12th of this month, my lord, date is
Then
given.
when it will be fixed? We don't have the 10
Yes,
tomorrow
because
to fill
small
up.
thing, my lord, because my lord,
Small thing
there
is
is a
there,
stay on it, my
obviously.
lord.
But how can we adjust now? This is the issue.
Then, my
After
lord,
1 week, after 1 week,
my lord, then date may be given, my lord. Otherwise, that is then difficult to list it, my lord.
just told you, nahi bo aru pai nahi. It won't reach.
Then, my lord, on
Because see,
15,
19 and 20,
15
we cannot give 19, 20 because these are the
15,
fixed for the motion matters only.
15,
19 and 20. Lots of
15,
motion matters are already being
15,
listed.
15 or 16, my lord.
15 key bar,
Monday.
Sunday.
No,
15
15
Sunday.
is
16 is full.
no, 15 is Monday, my lord. December
Monday
15 is
Sunday
Monday.
peak on about 20.
Oh, 25. It is already advanced, it is fixed. And then, my lord, the next 16, my lord, on Monday, my lord.
16, so it will not reach. I'll give it 16. 43.
44, my lord.
44. 16 for it. It won't reach. Lost matters are already been fixed on 12,
Because this is
15,
urgency,
14.
because otherwise, my lord, the
all
warrant
are
of
fixed.
arrest will be active, my lord. That is why.
We'll have list, yes. Let us see after 1 week. He will give some dates. We try to accommodate. We are trying, but if it comes, then not so.
To convene next week, lordship.
Okay.
May I please, the lordship, similar fair method. On 7.
I will try to accommodate. If he will see
Item 52.
the date, fixed date, he will definitely verify and will try to accommodate. But otherwise, we don't have any alternative because prior to vacation, there are lots
yes.
many places.
Lordship,
19, 20, we cannot give.
Item 52, lordship.
Yes, we'll give to you. Yes, son of
March
October.
over.
Okay.